May it please, your lordship.
Yes.
My lord, in regard to item number 1 is the top of the list. My lord, I am not asking for any adjournment. For the time being, your lordship kindly accommodate. I have a parted matter. As soon as I complete, I will come. And in regard to item 12, this is the hearing matter. My lord, I could not locate my friend. My lord, I have been engaged a few days back. So I will pray for adjournment when the matter reaches, because other side. Oh, yes.
I may dear my lord for the respondent. Some urgency, their lordship may, for the convenience of senior counsel, date may be fixed.
Lord, we want to file one additional application. After going through it, we found it is necessary. My lord, 4 weeks time may kindly be given, and I will not ask for any further time.
It is because some construction is going on, madam, and decree was in our favor. And time is the essence of the contract. Madam. That is the thing.
For the 4 weeks,
Yes, really.
nothing will happen. And if construction is going on, I will tell them not to continue.
My client
For
has said
such-
that my instructor me that construction is going on. Lordship has fixed it today for that. But for senior counsel, my lordship may give a date.
2 weeks, Mr. Datta.
My lord, kindly make it 3 weeks.
3 weeks. Okay. As agreed by learned advocates of both the parties, recessal is the matter. Oh, we'll fix it at then.
Yes,
Okay.
On 19th November.
19.
Much obliged.
May it please, your lordship.
Yes.
Lordship, may I pray for listing of this matter on 2019 if possible, lordship? This is the first.
Before hearing matter,
No, lordship, for orders, lordship. because
orders.
Notice was issued on 24th of.
Okay, okay.
Obliged.
And please, your lordship, my lord, hearing matters, pain recovery, MSCB, my lord,
When?
5th November, my lord.
Okay,
Should
could be
not,
possible.
not 5th, on 14th November.
Please.
Lordship, I'm praying for listing of an IA in a CRP that is going to be listed tomorrow. I'm praying that the IA be also listed tomorrow, Lordship.
Yes,
Okay.
Okay.
Yeah, please, my lord. My lord, I beg to mention item number 16, my lord, 116. And for the respondent, I have taken from the consent from the applicant, my lord. I pray this matter may come after 3 weeks, my lord.
We have no objection. We have for the appellants.
Mr. A.K. Gupta, learned counsel for the respondent with consent from the other side, press for listing the matter. When?
Your lordship, in 19th November or 21st, 28th?
28th November.
28th.
No, my lord, let it be in the December 1st date, my lord. I have some personal difficulty.
5th December.
All right.
May I please, your lordship?
Hmm.
My lord, I beg to mention item number 17 and 18, my lord. My lord, due to some emergency situation, my senior will not be able to come to court today, my lord. We have taken consent from the other side, my lord. Maybe listed on any other day. My lord.
Are you sure that you informed the other side?
Yes, ma'am. We have informed.
Mr. S.S. Mahmood, learned counsel with consent from the other side. Learned counsel for the appellant with consent from the other side, press for listing the matter. When?
Next week, my lord.
Next week? Not possible.
In the last week of November.
No, last week of November.
Last week.
Last week. May I please, your lordship?
Hmm.
Lordship, I beg to mention item number 23, lordship. That may be come up after 3 weeks, lordship.
Why?
Engaged counsel Mr. K.R. Borua, lordship, suffering from slip disc, lordship. So he is not in a position to appear.
Mr. Your good name?
As does, lordship.
As thus learned counsel appearing on behalf of Mr. K.R. Borwa. Learned counsel for the appellant, press for listing the matter after
3 weeks.
3 weeks. Pair load.
One pending CRP, my lord. One pending CRP, my lord. It was of the year 2015, my lord. Last listed 26-24, my lord. There was a direction to, my lord, file writ petition instead of the, my lord, I am for the respondent, my lord. Instead of the, my lord, the CRP, my lord, 115. So matter may come, my lord. The
When?
subject to lordship on any date, my lord.
Under what category? Under which category?
115. Yes,
Hearing orders admission.
order.
Orders. On 6th November.
May it please your lordship, praying for listing of the matter, your lordship, RFA 52 of 2024,
When?
7th November.
For?
For the matter is for stay, your lordship.
Possible. Order column.
For
the order
admission,
column.
admissions.
Under which
Admission.
one? Admission. Okay, 7th.
Hmm.
Yes, Lordship.
Okay.
Much obliged, your lordship.
Maybe please your lordship, with the consent of appellant, I beg to mention item number 14. Matter may be adjourned for a week.
Item number 14. UFO,
Respondent.
I'm
Your
for the
name?
Appellant, man. Appellant, man.
any objection?
No objection, date may be fixed, my lord.
Okay. It's agreed by learned advocates of both the parties. Resist and list the matter on. Kaveh?
Keep up.
Not first, second week, on 21st November. 21st November.
Earlier, several occasions they have taken time, my lord. So matter may be first week of November, my lord.
First,
No,
so
not
many hearing
possible.
cases, not at all possible. Just 1 or 2
Well,
weeks
well.
later,
Well,
on 14th, 14 November.
hearing,
Yes, on Thursday, 14 November.
obliged.
Lordship, I have filed a transfer petition criminal for transfer matter from Hosai to Dibrugarh, Lordship. The matter is fixed in Hosai on Monday, Lordship. If Lordship is. if-
Criminal matter, you mentioned the others in your bench who has been
transfer
taking
petition-
up the criminal matters.
Lordship, I have checked the roster, transfer matters, your Lordship is taking.
Transfer civil matters I am taking.
It is civil, not criminal.
Criminal.
May I please your lordship? I beg to mention for listing of an RSA matter, any date on November, your lordship.
Take a date from him.
November 26.
Okay.
Please, your lordship, I beg to mention one RSA for listing, lordship, in orders column.
When?
Any date, lordship, next week.
On 6th November.
May I please, Lordship?
Yes.
I beg to mention one RSA for listing in the others column
When?
on Monday,
Monday? Next Monday? Possible, Kaveh?
Monday, not Monday. Okay, Lordship, one question. 28.
8.
Okay.
No problem.
My lord, I beg to mention item number 10, my lord. For the appellant, my lord, the leading engaged counsel H.L. Moria met with an accident, my lord. Maybe fixed on the next month, my lord.
Well, he has informed me that he met an accident with
Hmm.
scooter.
Hmm.
He has a fractured leg.
Okay. As agreed by learned advocates of both the parties, recess shall list the matter on.
On 28 November. 28 November.
I love it.
This is part-heard matter perhaps.
Yes, yes. It'll be part of Malad. She was already.
Okay.
May I please, Your Lordship? I beg to mention for listing of an IA, my lord, for release of 50% amount in a MSc appeal, my lord.
When?
On Monday, my lord, I have filed on 3/10, my lord. I'm deeply aware.
For motion item number 22.
Excuse me. My lord, I am appearing for the Tibetan matter. And my lord, I am raising the maintainability of this petition, the question of maintainability, my lord. Because although the my lord, different provisions are quoted in the petition, but that is the order is basically passed.
Mr. Gupta, he is appearing for the petitioner.
Yes, ma'am.
He has a right to begin.
No, my lord, that is absolutely correct, my lord. I'm only saying that, my lord, this CRP is not maintainable. Instead, my lord, it is a.
No, first let him complete.
My lord.
So what was the pair before the learned trial court?
What happened, my lord? The suit was filed.
Hmm.
On the first day of appearance, we have filed an application. But since the arbitration clause is there,
Hmm.
on the basis, in the agreement,
Hmm.
which is the basis of the entire suit. So therefore, the matter has to be referred to.
Can you show me the agreement?
Agreement, yes, Lord. Lordship will find at page number 80. The agreement of sale of a flat.
1/8.
1A. Lordship will find the relevant clause at clause 23 at page 29.
Yes.
clause 23, my lord, that any dispute arising out of these deeds shall always be mutually resolved in speed in good faith. In exceptional case, it will be resolved by the arbitration as per law within the exclusive jurisdiction of Tingshuria. So what happened, without taking the recourse of resolving the dispute mutually, the plaintiff, that is the purchaser hearing, they have unilaterally filed a suit praying for the declaration and injunction. The court has granted injunction ex parte. Then we appeared and filed an application saying that since the arbitration clause is there, we heed by section 8 of the Arbitration Act, praying for the referring the matter to the arbitration. That application was rejected. Therefore, though you say the nomenclature of the application is Order 7, Rule 11, read with section 5 and 8 of the Arbitration Act, but basically the entire matter is being heed by section 8 of the Arbitration Act. So therefore, there is no, my learned brother has raised the question, had it been a petition decreed or rejected, invoking the Order 7, Rule 11, then 103 will come and it is an appeal, my lord. So that is not the matter hearing. Here only an issue is that section 8 says, my lord is aware that before submission of the written statement, I may file an application for referring the matter to the arbitration. The Supreme Court is very, very clear, lordship is aware, deal with the matter also similar in nature. That is the preemptory in nature. There is no other option, but it is on the obligatory part of the court to refer the matter to the arbitration matter. So therefore, when there is an arbitration clause, then there is no other option open in the judicial court, but to refer it matter to the arbitration matter. So this is the position absolutely clear. Now, by the impugn order, the learned judge has observed that there is two things in the findings emerged in the impugned order. The number one is the learned judge said that the original or certified copy of the arbitration agreement has not been filed, which is not true, because along with the plaintiff itself, the entire issue is based upon that agreement, registered agreement. The plaintiff has himself filed. And there is also an averment in the plain in paragraph 19, referring this clause 23 by the plaintiff himself. So that,
that may be, but does it mean that you have complied with the section 8, subsection 2 of the arbitration?
What happened, my lord? In the application itself, since the copy is not with us, it's on the basis, on the plaintiff itself, which the copy is there. So we made a prayer in the application itself to produce for a production of that document. That we have made a prayer. In the body itself, we have made an affirmation. And in the materials of record is clearly shows that the copy is available and the plaintiff himself relies upon that agreement. So therefore, that has been complied with. And the second observation, the learned judge has said that
whether you have enclosed, no, Mr. Dotto, have you enclosed the petition with this revision petition?
Yes.
At page number?
Yes. Lordship, kindly have a look. My application is page 63. Lordship, kindly
Where
have
is the averment that
Lordship will kindly have a look. Here, para 8, my lord. Para 8, page 66. Lordship has got it? Yes.
Okay.
And also I am made a prayer. In the prayer portion also I have said to directing the plaintiff to produce the original.
Okay.
That's so therefore, why section 8 says, my lord, is also appreciate that without producing the arbitration agreement, how could the court can have a look at that? But here in this case, that agreement is still on the materials of record. And we also made a prayer
Mm.
So therefore, that difficulties the court court cannot say that in the record the agreement is not there. And the second finding the court says, very short order, second finding the court says that the parties are not agreed to go for arbitration. Absolutely, that cannot be said. Because here section 8 says that there is no question of agreeing or disagreeing. If there is an arbitration clause, and the party cannot also, my lord, cannot say that the facts and
Okay,
circumstances.
okay.
My lord.
Yes, Mr. Gupta, what is your objection?
First thing, my lord, lordship may kindly say, my lord, section 37 of the Arbitration and Conciliation Act. my lord.
Mm. Yes.
Hearing, my lord. Appealable orders, subsection 1 is, my lord, notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from the original decrees of the court passing the order, namely, A, refusing to refer the parties to arbitration under section 8.
Mm.
So this is appealable order, my lord. So appeal will lie under section 37(1)(a), my lord. But this is an application under Article 227, my lord. So my submission, first submission is, my lord, this revision petition under Article 227 is not maintainable as there is alternative.
If we direct the registry to register it as an appeal, then
That lordship may.
I'm just helping, my lord, I'm to assist this honorable court. Under the Arbitration Act, the court means, court definition is there. Here that says the court. The court definition is, as per section 2(s), subject to correction, so it's the principal civil jurisdiction. There is a district judge. It is not this. The court under the Arbitration Act, my lord, is the principal original jurisdiction. That is the district judge.
mm.
So I'm respectfully differ with the submission of my brother. It is civil judge has passed in the civil suit. So therefore, there's a jurisdiction before the Honorable High Court is only to, having the superintendence of the supervisory power of the order of the court.
Mm.
Because he here says, from the following orders to the court authorized by law to hear the original decree of the passing the order. So here the court in the Arbitration Act, court is, Lordship will kindly have a look, section 2. Yes. 2E, man. It is commercial. High Court, yes. In the case of arbitration other than international such and such, the principal civil court of original jurisdiction in a district includes the High Court in excess of original jurisdiction, having jurisdiction to decide the question such and such. So 37 will come in different respect. In different respect.
Mm.
37, my respectful submission is will not cover this.
No,
Because
but
here we are exercising, this is not a first case. We are here, this honorable court has taken a jurisdiction under pretense in so many cases of rejection or allowing the application filed under section 8 in the civil jurisdiction.
no, Mr. Dutta,
My lord.
whenever alternative remedy is there,
This is not an alternative remedy, my lord. I'm
yes,
respectfully
in
submitting.
invoking jurisdiction under section 227,
Right.
the
But
law
that's
is also,
separate aspect. I do agree and I'm respectfully going down to this honorable court. It is absolutely different. Suppose the alternative remedy in separate legislation, etc., then we have to exercise that.
Mm.
But so far, this order has been passed by a civil court.
Mm.
That's a civil court, my lord.
Mm.
So it is covered under the CPC. I am filing an application under the referring to the section 8. I'm filing an application under Order 7, Rule 11 for rejection of the plaint under the Code of Civil Procedure. Read with section 151. Referring to section 8, saying that, see, look at section 8. The civil court has no jurisdiction. Supposing, my lord, a suit was filed before the civil court, and a question arose that it is by special statute under the Assam Municipality Act, section 138 or 226, the court is barred. Or file a civil suit, my lord, challenging a mutation order. Now, section 154 of the Assam Land Revenue Regulation barred the civil court jurisdiction. So therefore, I am praying that the civil court has no jurisdiction. Civil court accepted, did not reject my application. Then I cannot go to 154. I have to challenge that original order before the High Court under 227. So my respectful submission, we should not confuse, my lord. There is a very clear that I filed an application under Order Rule 7, Rule 11, read with section 151, referring the civil court to ask the civil court, please see section 8, wherein your jurisdiction is barred. The civil court did not accept my submission.
Is it your argument that the order was not passed under section 8 of the arbitration?
Yes, absolutely correct. Absolutely correct, my lord. The court says, no, I have a jurisdiction. I have a jurisdiction. Now, section 8 is the barring jurisdiction of the civil court. The barring jurisdiction of the civil court. So it is
No, you could not follow my point.
My lord.
My point is, is it your case that the order is not passed under section 8 of the Arbitration Act?
Yes, absolutely correct, my lord. I'm candidly for saying, Your Honor, that this is not an order, because if he invoke the jurisdiction of A, he has to refer it. The question is here that the section 8 barring the jurisdiction of the similar like, my lord, in the other statute also. Lordship will find section 30. Suppose your lordship is aware.
You come to this 37(1)(a), refusing to refer the parties to the arbitration under section 8.
No, I'm following. That section 37 will follow. Section 9, section 34, section 8. But here, the section 37 is not applicable in this case. But I am again reading the section 30. Not twisting anything contained in any other law for the timing in force. An appeal shall lie from the following orders. To the court, authorized by law to hear appeals from the original decree of the court passing the order. The appeal from the original decree of the court. Which court? To the court authorized by law to hear appeals from original decree of the court passing the order. That's fine. The district judge having a jurisdiction. Refusing to refer the parties to arbitration under section 8. Now, the question is, my lord, that this order passed under Arbitration Act. Our case is not like that. My application is under Order 7 Rule 11, read with section 151. I am inviting the court. I am not filing an application under section 8 before the court. I could not, I am not, where I make it clear. I am not filing an application under section 8, my lord. I am only saying, suppose, my lord, for an illustration, for a moment, my lord, I am filing an application suit before the civil court challenging a section 13 notice under the SARFAESI Act. Now, under the SARFAESI Act, section 34 saying the civil court barring the jurisdiction of civil court. Now, court has refused my application. So I have to come before this honorable court. Because all the
No,
state.
no, that's all right, but
But-
in which way? By filing an appeal or filing a revision petition? That is the question.
No, no, what my understanding
Hmm.
is that the Article 227 application is maintainable.
Hmm.
It's absolutely maintainable.
Hmm.
Because we are in the here High Court, this is not a first, we are regularly, we are here, because it's not, this court having a superintendent's power under the lower court. my
No,
lord.
no, there is no doubt about it.
Yes,
He has also not disputed about it.
my lord. No, I am understand, my lord. I am understand. Now, this is my respectful submission.
Mr. Doctor, in the petition, in your petition, upon which that Ms.J. case number 68 of 2024 was registered, there it has been clearly mentioned that the petition is under section 5 and 8 of the Arbitration and Conciliation Act.
No, Lordship.
Yes, yes, it is clearly mentioned.
63.
Read it.
And.
Oh,
No.
but basically, I cannot file an application under section 8 before the lower court.
Hmm.
Even I am saying that I am filing an application, I cannot file an application because there is no provision to file an application under section 8.
Hmm.
Section 8 is a substantive section, my lord.
Hmm.
It is not a procedural section.
Hmm.
I am filing an application under Order 7, Rule 11.
Okay.
For
Yes,
rejection of the
Mr.
claim.
Mr. Gupta, what is the other objection?
My lord, if my senior friend concedes that this is a petition under section Order 7, Rule 11, my lord.
Hmm.
Then my lord, lordship knows the bar under Order 7, Rule 11, my lord. Order 7, Rule 11 is rejection of plaint, my lord.
Hmm.
And 11D is, my lord, if any suit is barred by any other law.
Hmm.
My lord, subject to correction, my lord, I have not found anything in the Arbitration and Conciliation Act which bar any civil court, my lord. That is a preemptory, my lord. If the court finds that, my lord, there is an arbitration clause, and if
No,
there-
no, Mr. Gupta, some recent judgments of Supreme Courts are there. That if there is arbitration
Yes,
clause,
yes.
then
No, no, court
Hindustan
has no
Petroleum
order of
Corporation is
substance.
there.
No, my lord, that is there, but if that is section 8 application, my lord, here, since the senior friend has come to have considered that this is a petition under Order 7, Rule 11, my lord. So, my lord, may kindly.
It is barred by law, therefore Order 7, Rule 11.
Yes, my
It
lord.
is barred by law. Now 103 will come, Rule 103 will come when decree is passed. When plaint is rejected, my lord, then it is appealable. 103, Rule 103 says. There is a separate thing. If the plaint is rejected, under 7 Rule 11, then the court has to grant a decree. And that is appealable. That is there.
No, Mr. Dutta, can you show any judgment or order of this court by which the petition rejected by the trial court file under section 8 of the
My lord, I
Arbitration Act?
just pointed out,
Hmm.
my application is Order 7, Rule 11D. That is barred by law. If any application is barred by law, then the court has to return it and ask the party to approve the appropriate form. That is the procedure under the Civil Procedure Code.
Hmm.
I am saying that this application is barred by law
Hmm.
because Section 8 is there.
Hmm.
That is my simple contention, my lord.
Hmm.
So if it is barred by, court has said, no, it is not barred by law.
Hmm.
So it's 227, my lord.
Hmm.
Be it simple. So therefore, at this stage, your lordship may kindly admit this and state the further proceed.
No, we'll
But then-
finally dispose of the matter.
Oh, my.
We'll finally dispose
Yes,
of the matter,
yes,
but
yes.
you have to satisfy this court that this petition is maintainable under
My
section 227.
submission is that it is a petition under Order 7, Rule 11D. It is barred by law. Why barred by law? That's Section 8 of the arbitration. So it is basically a petition under Order 7, Rule 11.
Hmm.
Now, Order 7, Rule 11 petition is rejected,
Hmm.
as is similar in our case.
Hmm.
Then we are before this honorable.
Hmm.
Or your lordship is more clarity fixing tomorrow. I will clarify.
Not tomorrow at 2 p.m. today.
2 p.m.
2 p.m.
Because there are, the
No, all
lordship
right,
has entered
that's all right. Only the question is that if alternative remedy is there, then whether this petition under
No,
27 is
no,
pending.
that aspect that does not come. Why, my lord? I'm just saying
Hmm.
that it is, my application is order
Okay,
seven rule.
okay, I will hear you at 2 p.m.
No,
My lord, can it be tomorrow? I have a parted matter, my lord.
No.
lordship may dispose.
Item number 2.
Please, your lordship.
Hmm.
What if the amount has been credited to the petitioner's account?
Yes.
And then may close it.
Credited.
Credited, lord.
So the direction has been complied with.
Yes, Mr.
Yes, sir.
Heard Mr. NBP Sinha, learned counsel for the petitioner, and Mr. P.N. Sharma, learned standing counsel for the respondent number 1, 2, and 3.
1, 2, 3, lord.
1, 2, and 3. Then none appears for the respondent number 4 and 5. Person to the deliberation held on 1/10/2024 in this court, Mr. NBP Sinha, learned counsel for the petitioner, apprised this court that the amount which the petitioners were entitled to has already been credited in the account, in their account. And as such, the grievance of the petitioners raised in this petition has already been addressed by the respondent authorities, and as such, this petition may be disposed of. Having heard the submission of Mr. Sinha, learned counsel for the petitioner, and also considering the submission of Mr. Sharma, learned counsel for the respondent number 1, 2, and 3, this petition is then closed.
Item number 3.
Yes.
An appeal filed against an order very hastily passed by additional district judge Mr. J.K. Dash, while he in charge of the civil judge. We have filed a suit, my lord, for a declaration, an injunction, etc. Now we are in possession of the land. Subsequently, on subsequent events, that something has happened, apprehending my disposition, I am filed an application for injunction. Subsequently, after we have filed a suit in 2023, on 26/9/2023. And subsequently, we have filed the injunction petition on 3rd of April 24 on subsequent developments. Now, on the day of filing of our application, the civil judge was not in session. So it was put up before the additional district judge, Mr. J.K. Dash. On the next day itself, without going into the merit, the application was dismissed at its threshold, my lord, on the point that is not maintainable. Why not maintainable? Because an application has been filed by the opposite party saying that there was no prayer in the main suit. And the learned judge, without going into the plaint, etc., saying that there was no prayer. or permanent injunction? We have prayed two things. One is mandatory, one is permanent, temporary injunction. Ad interim mandatory injunction we prayed. Mandatory injunction was not prayed in the main suit, but the permanent injunction prayed. The impugned order, Lordship will find at page 57. Yes. The Lordship kindly comes to the operative part. Page 58, bottom para. I have perused the plaint. Incorrect statement by the learned judge, my lord. I am constrained to say. He has not perused the plaint. I have perused the plaint of title suit number such and such minutely, he has said, and found that the petitioner has not claimed relief or permanent injunction. I'm just, for a moment, I'm just told here, my lord. The learned judge say that he has gone through the minutely and found that there was no permanent injunction prayer. Lordship, kindly have a look at page 16, my plaint. And page 30 is the prayer. Proceed, Lord. Finally comes to Lordship, page 32, bottom prayer. Permanent injunction. This is got it. Permanent injunction, restraining the defendants and their helpers, associates, such and such, from interfering, disturbing in any manner the plaintiff in continuous peaceful position. And a judge said, my lord. Absolutely. How could learned judge say that I have perused the plaint? On this count alone, Lordship, this honorable court may interfere in the impugned order. And therefore, the finding is, my lord, which claimed the instant petition such and such. Now, page 59 of the impugned order. Again, the learned judge has made a false statement. I must say it is a false statement because it is unfortunate, my lord. 59. 59. The learned advocate for the petitioner has submitted. There is petitioner has submitted, plaintiff petitioner has submitted that on the basis of subsequent events, they are compelled to seek such and such, correct? However, he considered that said subsequent event have not been incorporated in title suit by filing proper petition, correct? And also the relief claim in the such and such. He also submitted, this is incorrect statement. He also submitted that no relief of permanent mandatory injunction and permanent injunction. Mandatory injunction is not there. And permanent injunction as prayed for in this petition has been claimed in title suit number such and such. Absolutely not correct, my lord. Mandatory injunction I have not prayed. For the permanent injunction, which I am pressing for, that please ask them not to disturb my position. That is there. And therefore, Lordship will find in the last part of the order, page 60, as the petition is itself not maintainable. How could it is not maintainable, my lord? As such, without going into the factual aspect of the statement made in the petition, this court of the opinion that the instant petition is not tenable under the law and the petitioner is not entitled for any relief as claimed in this petition. But fortunately, we have come before this honorable court, and on the motion itself, my lord, this honorable court has granted interim relief in the IA that not to disturb and not to make any construction. My respectful submission, because we are here under under the appeal. In fact, my application was not disposed on merit. For my respectful submission, please remand the matter before the learned civil judge to hear the parties afresh, decide the matter on merit, until the such time here, I am being protected. Because without merit, the application has been disposed. only on that point, which
Yes,
is not
Mr.
correct. That is
Sir?
my only suggestion.
My lord, may kindly come to the plaint, my lord, the prayer, what is the prayers made in the plaint, my lord, that is the page 30, my lord, 30, my lord.
Hmm. Hmm.
30, my lord, first is declaration of right possessory title, my lord. Then, my lord, may come to page, next page, my lord. Declaration that the defendants have no any right, then, my lord, cancellation of registered sale deed, issue of precept. Then, my lord, declaration of mutation order, all this, my lord, and then, my lord, page 32, my lord. Second, my lord, prayer, my lord, mandatory injunction directing the defendant number 10 disconnect the illegal electric connection from the schedule 2 by removing meter therefrom. This is a direction to, my lord, electricity authority. Mandatory injunction is sought, my lord. And then, my lord, last prayer, my lord, what my senior friend has pointed out, my lord. Permanent injunction restraining the defendants and their helpers, associates, workers, assigns, representatives, transferees, employees, etc. from interfering, public disturbing in any manner the plaintiff in his continuous peaceful possession over the scheduled land. That is his prayer, my lord. What he sought. Then, my lord, may come to the petition, that is the mistake case, my lord, that it starts from page 36 and prayer lordship will find at page 50, my lord, 50.
Hmm.
It is there. I'm reading the prayer portion only, my lord. It is therefore prayed that your honor may be pleased to take into consideration the above submission and then be pleased to issue ad interim mandatory injunction against the opposite party number 1 and 2, restraining them, their dependents, helpers, family members, relatives, workmen, representatives, assigns, transferees, etc. from illegal construction of boundary wall on the eastern side of the boundary of the Schedule 1 land and directing the opposite parties to demolish the unauthorizedly and illegally constructed boundary and remove all the construction materials unauthorizedly kept, used, stored by the opposite parties on and over the Schedule 1 land and grant ad interim temporary injunction restraining the opposite parties, their dependents, helpers, family members, so and so from changing the nature, character, and topography of the land as described in the Schedule 1 here to below in any manner, modes whatsoever and whomsoever, and also from disturbing or obstructing the plaintiff from cultivating paddy and other seasonal crops on and over the suit land till disposal of the suit. Well, the prayer made in this mischief case and, my lord, in the plaint is totally different, my lord. There's no correlation, my lord. Although the word is there, mandatory and, my lord, permanent injunction, but whatever is sought in the mistake case is totally different, my lord. No, it has no connection with whatever is prayed in the plaint, my lord. That's why the court has rightly come to a finding that, my lord, since there is no permanent and mandatory injunction is sought for with regard to these matters, my lord. And, my lord, the pleading, whatever is there in this mistake case, my lord, is nothing. I can point out the paragraphs, my lord. Most of the facts are not stated in the plaint, my lord. These are the new facts, my lord. They ought to have amended their plaint, my lord. But these facts are not incorporated in the plaint, my lord. That's why the court comes to the finding that there is no statement, my lord. And if lordship knows that, my lord, if there is no prayer made in the main, there is no main relief is sought for, then, my lord, as a subsequent relief for, my lord, the injunction cannot be granted in these matters, my lord.
No, in the main petition, title suit, it has been mentioned about mandatory injunction, permanent injunction.
Yes, my lord, one mandatory injunction is with regard to restoration of electricity connection, my lord.
Hmm.
And permanent injunction with regard to disturbing his possession, my lord.
Hmm.
But here, in the mistake case,
Hmm.
he has sought many reliefs, my lord, that some illegal construction is going on. They have piled over some construction materials. And, my lord, these prayers are sought on the basis of the pleadings, what is not made on the plaint, my lord. Because this is a petition filed subsequently, my lord, after about a year. So they ought to have first amended their plaint, my lord. Because there is nothing is sought in the main petition, my lord. Totally different prayers are made in the end. Lordship knows, my lord, if there is no relief is sought in the plaint, then that cannot be guaranteed in the, my lord, miscellaneous applications, my lord. My lord, in this regard, I'm relying on one judgment, my lord. 1981, 283. My lord, I'm referring to paragraph 4, my lord. I'm referring to paragraph 4, my lord. Next page, my lord. May I read, my lord? Next, coming to the question regarding order data 3493 in Miss case number 1/89, that was an order of maintenance of a status quo, making the earlier order of injunction absolute. It may be stated herein that no such prayer was made in the plaint by the plaintiff. Only 3 prayers were made in the plaint, but without prayer of an injunction, an order of maintenance of a status quo was granted. It is well settled that without making prayer of permanent injunction, no temporary injunction can be granted. When a permanent injunction was not sought for, the question of granting temporary injunction does not arise. That aspect of the matter was not taken into consideration by the learned Munsif, and setting aside the order of cancellation passed by the Deputy Inspector of the School is illegal. So that is the proposition of law, my lord.
Any other point?
That is the main thing. And my lord, in this case, my lord, we have the respondent have filed their preliminary objection only. And be relying on that, my lord, the court has held that since there is no relief sought in the main plaint, my lord, therefore the court has rejected the petition as not maintainable.
Yes, Mr. Datta.
Nothing to be, this is there, your lordship. It is very clear that the not to disturb my position. Court has granted a status quo. And that is absolutely a good order. I'm praying for permanent injunction. That not to disturb my position. That is my prayer only. And this honorable court also granted status quo order and not to construct. So let the matter be remanded back. Take a fresh decision on the matter. Because lordship, parties cannot be remedieless. The question is, after filing of suit, if something is happened in urgency, it is not a rule that I have to file an order 6, Rule 17 application for amendment, then we have to file interim injunction, etc., etc. My apprehending of disposition is there, and I'm made a prayer in the main suit. Subsequently, a final application under Order 39, Rule 1 and 2. Had it been the position, I have not prayed anything in the plaint, then the matter would have been different. I have prayed. The learned judge has wrongly asserted that no prayer is there. Absolutely wrong, man. So that is my only proposition before this honorable court, humble submission. Let the matter be remanded. Decide the matter of merit until
Yes.
I am be protected.
Mr. Gupta.
With due respect, my lord, I'm not agreeing to my senior friend's submission, my lord. And my lord,
Well, lordship may take a call and decide the matter.
my lord, on merit also, my lord, I have purchased this suit land by way of a registered sale deed, my lord. That is admitted in the plaint, my lord.
The merit I am not touching because lordship is, we have filed a document before the learned lower court. Circle officer said I am in position. Circle officer said I have a giving a 12 lakhs rupees 2008. I'm not, because I'm not buttressing the merit, madam, because this court is only the supervisory power. I'm not on the merit. I'm only saying at this stage the matter may be remanded to take a fresh decision on the matter. That is my only respectful submission. And learned, this honorable court may take a call. Until that period, I may be protected. And this is a settled position. If I am not praying, then there is something difficult.
Okay, well, pass the order.
Yes, sir. Grateful.
Obliged.
Item 23. Oh, sorry. Item 4 for orders.
May it please your lordship.
Hmm.
On earlier occasion, the court directed the registry to correct the address of the respondent number 331 to 34. As per office note dated 23/9/2024, the address has been corrected of respondent number 1 to 3. So Lordship, I pray for taking fresh steps upon respondent number 31 to 34 on corrected address.
Third miss, your good name?
S. Ajmi,
Yes,
S. Ajmi, on behalf of R. Chaudhary.
learned counsel for the. Have you filed Wakalatnama here? You have Wakalatnama here?
On behalf of me, your lordship, then
On your behalf, but whether
Today
she has
is
filed
our-
Wakalatnama here?
first date.
Pardon?
Today is our first date. lordship.
And
Where
that's all right, but whether she has filed
Your
Wakalatnama?
lordship record my name.
Third miss, R. Chaudhary, learned counsel for the applicant, applicants, and Mr.
Yes, Rana.
S. Rana, learned counsel for the respondent number
1, 2, 4, and 5.
1, 2, 4, and 5. Ms. Chaudhary, learned counsel for the applicant, submits that she has collected the address of the respondent number 31234. And she may be granted some time to take step upon the aforesaid respondents. Care is accordingly allowed. Step be taken by registered post with ADN. In a week from today. List the matter after 3 weeks. After 3
2
weeks,
weeks, lordship. It's 3 weeks.
2 weeks.
Yes, apply.
Item 5,
Office note says one record received, madam, one record, madam. On record, madam, on 22/10/2024, money appeal is received, madam. And money suit, madam, 41 is not received as per the office note 13/9/2024. But there's the order, madam, on 16/8/2024, madam. Lordship may produce the order at 16/8/2024, madam. Madam, there's consent, madam, to argue this matter, madam, on, if not received, the largo file, madam. So, madam, here, madam, record is not there, madam. So, may I pray, madam, another date may, short date may fix, madam, for hearing, madam, hearing with the record, madam. Record is not available today, madam. Short date, madam, any date.
No,
madam.
the problem is whether the record has been received or not.
It is, madam, on this office note, speaks, madam, on 22/10, 22 October, money appeal is received.
No, in absence of the other record, can we hear the matter?
Yes, Lordship.
The short, madam, limitation we are
Not
regarding.
issue, Lordship. Not using limitation, Lordship.
Limitation, madam, we filed during COVID time, madam, it was my disclosure of madam, and subsequently we filed a petition, madam, for limitation, madam, it was dismissed, madam, and accordingly appeal was dismissed, madam. So far, madam, this substantive question of law also framed, my lord, regarding the only limitation, period, regarding limitation. The order of this honorable court, my lord, the substantive question of law was framed on, my lord. My lord, it is 5/6/2024. Whether the-
Now you tell me whether we will issue reminder to the learned court for transmitting the money suit number 41 of 2018.
That is my.
There is already an order, Lordship. Both the parties have consented.
Only
The record is not necessary because their application was rejected on the ground of delay in the appeal. So consequently, appeal has been dismissed.
Whether the substantive question of law was, whether the approach of the first appellated court in dismissing miscase for condemnation of delay was in accordance with law. This was the substantive question of law, madam. And I am told.
So
my-
record is not necessary then.
Not necessary, Lord.
Yes, but on this, madam, the other documents are there, madam, the judgment, only my evidence part is not there, and that is there, madam, evidence part, madam. It was expert hearing, madam. Expert hearing, madam, we are not.
Lordship,
present.
suit
No,
was
if
fi-
only substantial question is law relates to only
Yes.
the point of limitation,
Yes, Lordship.
then why record is
Yes,
necessary?
madam. So, madam, this main, the other record is, the money appeal record is received, madam, as per the order.
Mm.
So that sort that may fix, madam, we will argue this matter, and on the, matter fix on hearing column also, madam. The orders is in.
Okay. Heard Mr. S.K. Medhi, learned counsel for the appellant, and Mr. Yes,
Yes, second.
S. Rekha, learned counsel for the respondent. Office note dated 22/10/2024 indicates that money appeal number 03 of 2022 has been received. but money suit number 41 of 2018 has not yet been received. But it is submitted at the bar that without the record of money suit number 41 of 2018, the matter may be heard, as it relates to only as the substantial question of law relates to only limitation. In view of the submission of learned advocates of both the parties, it is provided that registration is the matter for hearing
Yes. Date may fix.
on sorted
7th of November.
19. 7th of November, we have some other matters.
The specific date, he is a.
Yes, 19,
On
19,
19 November.
19, I am myself.
12.
12.
It's a Tuesday, Lordship.
Okay,
12,
Because we are suffering, Lordship. Money degree has been
Okay,
paid.
okay.
14, 14. 12,
He always took
because
5 adjournment earlier also. In every way, he remained not in.
14 November.
14.
okay,
Interim order earlier continue.
okay, interim order for service shall continue. It is provided that no further adjournment
yes,
will be
ma'am.
granted to
Yes,
the
ma'am.
appellant.
Only matter may come on hearing column.
Yes, no, definitely it will come.
What number 6 and 7?
In this case, complying with your lordship direction, also we have paid total 1 lakh to the wife lordship. And as my colleague is lordship suffering from some ailments lordship, and his leave of absence is also there, he could not file our affidavit on time lordship. So on 19th and 20th lordship, already the amount has been paid to the wife, as directed by your lordship in the last order.
Mm.
We could not file the affidavit in connection with the ceremony. So only 2 days time will be granted, by next week we will file it.
You received the amount?
My lord, as of now, my lord, so far as telephoning instruction, out of your lordship's order for depositing 50,000, we deposited 25,000. Few minutes back.
The total 1 lakh already paid. So the documents are there, therefore have.
Maybe you submitted, my lord, few minutes back. It may be also, I don't know. So far as the, well, look, that is not the issue now, my lord. The issue is that lordship trying for last so many months to dispose of the matter. Because, my lord, 2016, this lady is with a child, now school going child, is not getting the money on pretext of one or the other. And his source of income is, fixed income is now 82,000, my lord, salary, remaining other things, my lord, which is according to me more than 2 lakhs, my lord, per month. Now, my lord, she is suffering from some cyst which needs to be operated early, number one.
No, Mr. Talukdar, if he is not ready, then okay, we'll fix a date.
My
For
lord,
that.
my lord,
So that
to
part
file the
lordship may-
affidavit, my lord,
That part lordship may clarify, because my instruction is that amount is paid. Now
My lord,
he is
my lord,
saying that he has
my lord,
not
deemed to be
received.
paid, my lord. I'm,
Because
yes,
if-
he's saying I'm believing it, my lord.
No.
I have no objection in
So
that.
that has to be on record.
This is a
lordship.
plea
If
of
my
delaying, my lord.
case goes against me, then that amount has to be adjusted in the final amount.
My lord,
That has
this
to
is-
be clarified. He cannot also skip that part, lordship. So far I
my lord,
understand.
only for delaying, my lord. My lord,
No, that's all right.
I'm accepting it is deposited, my lord. He's
So that
saying, my
means
lord,
how he can say lordship that amount was not paid in the initial stage.
I believe him, my lord, as he is submitted before lordship, it will be definitely correct, my lord. Maybe at the last moment he has submitted, my lord, deposited. That is not the issue, my lord. Issue is that kindly, my lord, you have lost repeatedly listed for early hearing.
How many matters have been fixed?
Next Tuesday. First list is not at all, but. 29.
22. So, Mr. Ahmed, short date is not possible for hearing because on that day we have already fixed 22 matters for hearing.
Any day lordship may fix. I will be
Any
there
date,
and I will
we
give you
also not interested to adjourn the matter for a indefinite period.
Lordship may fix a particular date. I will argue the case, and I will also bring on record that on 19th and 20th we have paid the amount, but he has said at the last moment. This is not the last moment. Today is 24th. On 19th and 20th we have paid the final amount as directed by your lordship.
My lord,
That
sometime message,
lordship is lordship something different. And look, one request lordship that from my client which he has said lordship, the amount was not utilized for the purpose of our medical treatment lordship. only regarding that in between lordship, they may file any affidavit, they are showing any medical document, that lordship may only direct.
That point, my,
Because we have complied with your lordship's direction, and only because of the fact that they said that for medical purpose, money is required. What treatment they have taken after getting the amount, only that, only one prescription, one document, anything they can submit, lordship. And by the next date, I will try for disposal, lordship. Only that document they
My
may
lord,
produce,
may I
lordship.
make
That oral
some
submission,
submission?
that lordship is not telling with the instruction which I am getting from my client, lordship.
my lord,
So therefore, they may submit an affidavit. I will also submit. Lordship may fix it Monday, Tuesday, any day. I will appear for final disposal. And by this time, they may also file their affidavit showing that the amount which is received for their treatment, they have utilized for treatment. That may they can file. Only that much request to you.
my lord,
Okay. 4th of November.
By this time, they may also file showing any document also.
my lord,
Because they have submitted before this court that they are suffering from serious ailments.
Mr. Ahmed, that is not the issue before the court.
No, my
It is
only
her entitled amount. So how she can spend, it is her prerogative.
No, my only submission to your lordship is that when someone is coming to a court, he should come with clean hands. Only
That's
that
all.
much. So if he is saying that money is required, then okay. If your lordship directs, I will pay. But they have said that she is seriously ill, ill condition, and those things are there. Therefore, lordship has directed to pay immediately rupees 1 lakh. Yes, somehow he managed and paid lordship. So therefore, only my request is that what treatment they have taken during this period, only to limited extent.
my lord, may I make submission on this, my lord? I may be heartily kindly, my lord. On the day one,
You produce the documents before the court on next date.
my lord, what, let me. first-
Any
my-
documents.
Let me make
No,
submission.
today.
my lord.
No,
No, my lord,
no.
what you said is absolutely incorrect, my lord.
You see behind, many advocates are waiting for their turn. Since
No,
we
my
are
lord.
not hearing the matter
No,
finally,
no, my
we
lord,
cannot.
my lord, what
No,
my
no.
submission is absolutely wrong.
Sorry,
my lord. I'm
sorry.
very hard, my lord. My lord,
Sorry.
my lord. I should.
Sorry.
That what your lordship is making submission is wrong, my lord.
Mr. Talukdar, you are not allowed to submit. As agreed by learned advocates of both sides, SSL is the matter on 4th of November.
My lord, I have not agreed.
Yes,
my lord.
provided that-
Kindly may not be recorded my agreement, my lord. I will be in problem, my lord.
Pardon?
My agreement may not be recorded that I agreed on 4th, my lord. Kindly.
Then,
Your lordship. Your lordship. It is not that.
okay, then I am releasing the matter from here.
I'm not on that, my
I am
lord.
releasing the matter from here.
I will be in problem, my lord.
Okay, all right.
I will answer this, my lord, to my
Uh,
client. my lord.
Both the
For
parties
long
are
sleep,
represented by their engaged counsel. SSL is the matter before any other bench without me.
Oblige, your lord.
For hearing item 8 and 9.
Lord, this matter fixed for I will written notes. I will prepare the. Why do it?
So this matter was fixed today only for submission
No,
of
Lord,
this
Lord,
written
Lord.
agreement. We can fix it for judgment.
Lodge.
Both the parties are represented by their engaged counsel. Argument concluded. Judgment reserved.
We have also submitted our written argument.
Yes, got it.
Deep level.
Much of it.
Item 11.
Make me this manner. But this second appeal is against concurrent findings. The respondents as plaintiffs, my lord, they filed a suit against the present appellants for declaration of right title interest, recovery of possession in respect of Schedule A and Schedule B plot of land, and for permanent injunction. my lord. The suit was decreed. Against that, we filed an appeal. The appeal was also dismissed. my lord. Against that, we have filed a present appeal. Now, my lord, when the matter was last taken up, I had raised an issue, my lord. My lord, may kindly come to page number 35 of the judgment. my lord. That is the order portion of the judgment.
Page number 35
35
of the appeal.
of the appeal. ma'am. That is the judgment of the trial court. Order portion. ma'am.
In the appeal, the pages are not numbered.
My lord may take up then the trial court judgment, my lord. Internal page number 6. Trial court judgment is marked as annexure 5, my lord. It starts from page 30.
Page number?
Internal page 6. And the running page is 35, my lord. Last page.
Yes.
Order portion. my lord. In the result, the plaintiff suit is decreed on contest with cost by declaring right title interest of the plaintiffs over the entire Schedule A land and over 1/4 part of Schedule B land. My lord, may kindly take note of this part. 1/4 part of Schedule B land. It is further declared that the defendant number 3 and pro forma defendants do not have title over more than 3/4 part of the land described in Schedule B of the plain. The defendants are being the custodians of Schedule A, B, and C schedule land are liable to surrender possession to the plaintiffs. A decree for recovery of khas possession of Schedule A and Schedule B plot of land by evicting the defendants is passed. My lord, declaration was given in respect of 1/4 part of Schedule B land. And recovery of possession has been given in respect of the entire Schedule B plot of land. That was the objection I raised, my lord, on the last occasion. In the prayer portion also of the plaintiff, my lord, they have sought for a declaration in respect of only 1/4 portion and recovery of possession in respect of the entire Schedule B plot of land, my lord. That is contradictory.
Where is the plain?
Plaintiff, my lord, will find at page number 6 to 12. Prayer portion is at page number 26, my lord. Para 11. Para 26, para 11. The plaintiff therefore claims and prays for a decree declaring that the title of the plaintiff over the entire land of Schedule A and over 1/4 part of the land of Schedule B. A decree declaring that the defendant number 3 and pro forma defendants do not have title over more than 3/4 part of the land of Schedule B. I'm skipping the B portion, my lord. C, a decree of khas possession for recovery of land of Schedule A and B, evicting the defendants. So declaration is sought for, my lord, only 1/4 part and recovery of possession in respect of the entire Schedule B plot of land. And accordingly, my lord, the learned trial court has passed the decree in favor of the present respondent in respect of 1/4 portion, but recovery of possession in respect of the entire Schedule B plot of land. That has been affirmed and upheld by the learned appellate court, my lord. So that's why, my lord, a substantial question of law was framed, my lord. 4 substantial question of law. The first is, my lord, with regard to the perversity in issue number 5, my lord. That was not decided as per law, my lord. If declaration is given in respect of 1/4 portion, then recovery position would also be in respect of 1/4 portion, not in respect of the entire Schedule B plot of land.
No, in the pair person in the title suit,
My lord,
decree is for position of schedule A and B
my lord,
plot of land.
my lord. Whereas in prayer number A, my lord, declaration is sought for 1/4 part of Schedule B.
Schedule?
1/4 part of land of Schedule B. Prayer A.
Mm.
So prayer A.
No, no, 1/4 part where it is mentioned.
My lord, para 11A prayer, a decree declaring that the title of the plaintiff over the
Subsequently, it was amended.
subsequent amendment.
Yes. Title of the plaintiff over the
1/4 part of land of Schedule B. My lord, come to page number 26, my lord. There are two claims, my lord. One is amended, one is unamended, my lord. I'm reading the amended claim. Page 26.
yes.
Para 11, prayer 1A, a decree declaring that the title of the plaintiff over the entire land of Schedule A and over 1/4 part of land of Schedule B. So if I read this prayer with prayer number C, my lord, a decree of khas possession for recovery of land of Schedule A and B. So here decree for recovery of possession is sought for Schedule B, whereas declaration is sought for only in respect of 1/4 part of Schedule B. And accordingly, judgments have been passed on the basis of this prayer matter. So my contention is that, my lord, if declaration is given for 1/4 part, then recovery of possession also ought to have been given for only 1/4 part, my lord, not for the entire Schedule B plot of land.
No, this pair number A and C.
My lord.
In C, it is mentioned the entire part.
Entire part, but declaration is sought for only 1/4, my lord. That is what I'm raising, my lord. If declaration is given for 1/4, then recovery of possession also has to be given in respect of only 1/4.
It cannot be entire plot of
For the
land.
entire, my lord. Because without seeking declaration of right title interest of a plot of land, my lord, recovery of possession cannot be given. That is settled proposition of law. Whatever you are seeking declaration only in respect of that portion of land, you can sought recovery of possession or confirmation of possession.
So where is the substantial question of law?
My lord, it was framed on 15/2/2019. 4 substantial questions of law were framed. First one is whether the judgmented decree suffers from misreading, non-reading of the pleadings and evidences, as well as misinterpretation of the documents adduced by the parties, and as such resulted in wrong and perverse finding in issue number 5. Issue number 5 is the most important and vital issue, my lord. Whether the plaintiffs, that is the present respondents, they have right title interest over the Schedule A and Schedule B plot of land. Thereafter, my lord, second is with regard to section 101 of the Evidence Act. The burden was shifted on me, my lord. Although I was the defendant, the burden was shifted on me that I could not prove my case. So accordingly, the plaintiff's suit was decreed, my lord. Their case was that, my lord, if I may take, my lord, to page number 24 of the plain, 25, para 1, that the land para one.
Hmm.
That the land measuring 4 bigha 2 kotha 2 lesser described in Schedule A below, owned and possessed by Teshmati Beva, along with other movable property described in Schedule below, who died on 27/10/2000, survived by his her brothers and two sisters, that is the plaintiffs and the defendant, who are not the legal heirs of Teshmati Beva, but one is her adopted daughter and the other is her daughter-in-law. So my lord, 4 bigha 2 kotha 2 lessons of land is the Schedule A property of land. And they are claiming that they are the legal heirs, being the brothers and sisters of late Keshmati Beva. They are entitled to get the property and not the present defendants, because the defendant number one is the adopted daughter and the defendant number two is the daughter-in-law of Keshmati Beva. It ought to have been son-in-law, but they have written as daughter-in-law. Now, my lord, how Keshmati Beva became the owner of Schedule A plot of land? They have not at all whispered anything in the plaint, my lord. Straight away in the evidence, my lord, they have produced the certified copy of a sale deed, my lord. In the plaint, my lord, there is no mention how Keshmati Beva became the owner of Schedule A plot of land, my lord. Without any pleading, my lord, the learned trial court has held that they have not failed to produce any documentary evidence, and they have, in fact, on the contrary, the learned trial court has said that, my lord, they have they are the right, they have right title interest over the Schedule A plot of land. Now, how, my lord, the learned trial court has deciphered that, my lord, they have become the owner of Schedule A plot of land without any documents, without any supporting evidence, my lord? That is a misnomer, my lord. So, my lord, Schedule A plot of land, they have failed to state how they became the owner, my lord. Straight away, they have stated that Keshmati Beva is the owner of the plot of land. Whether she has inherited the plot of land, whether by a sale deed, gift deed, will, how, my lord? Absolutely nothing, my lord. And with regard to, my lord, second para, my lord, that the land measuring 4 bigha 1 kotha 0 lessons described in Schedule B below was originally owned and possessed by Muhammad Ali, who died on, that is the husband of Keshmati Beva. And after his death, his only wife, Keshmati Beva, inherited the same. Accordingly, she got 1/4 share of the aforementioned land. That is 1 bigha 0 kotha 6.5. And the same is being inherited by the plaintiffs as a legal heir of Keshmati. Now, they have stated that 1/4 share of land out of 4 bigha 1 kotha 0 lessons. But in the schedule of the plaint, my lord, there is absolutely no boundaries, no north, south, east, west, my lord. That what portion of 4 bigha 1 kotha 0 lessons, 1 bigha 0 kotha 6 lessons out of 4 bigha, my lord, she inherited, they have not mentioned. No schedule, nothing, my lord. The description is vague. In spite of that, my lord, the learned trial court has declared the suit, and they have raised one more contention that the defendant number one is the adopted daughter. Whereas, my lord, they have failed to produce any evidence to show that I am the adopted daughter. In fact, the document number 3, that is the Khatian that they have produced, it clearly goes to show, in the cross-examination part of their plaintiffs, my lord, it clearly goes to show that I am the daughter. Exhibit 3, that is the Khatian, my lord, there it is clearly written that Meherjan Bibi is the daughter of Muhammad Ali in Keshmati Beva. So the learned trial court has failed to take note of that aspect of the matter, and straight away has held, I'll be coming to the judgment portion, madam. Straight away has held that they have produced certain documents which shows that I am not the adopted daughter. I am the adopted daughter. From where, which documents, there is absolutely no mention. May I take Milo to the judgment, Milo, trial court judgment? The main issue is at issue number 5 and 12 at page 33, Milo. So, my lord, my first point is that the order portion, that is the prayer portion, that is contradictory. Secondly, my lord, how adoption was taken or how it was done, my lord, they are absolutely none. No evidence to show that I am the adopted daughter. Thirdly, my lord, in respect to Schedule A property, my lord, how Keshmati Beva became the owner of the plot of land, there is no pleadings, my lord.
How Keshmati Beva
became the owner of Schedule A plot of land? No pleading, my lord.
Yes.
At page number 33 of the judgment, issue number 5 and 12, that deals with right title interest of the plaintiffs over Schedule A and B plot of land.
Yes.
Both these issues are the real points of controversy between the parties. Before entering into oral and documentary evidences of plaintiff side, let us have a look over the prime contentions of the plaintiff side and the defendant side. After careful and meticulous perusal of plain and written statement, it appears before the court that the plaintiff instituted the suit for declaration of right title interest and recovery of possession, contending that late Keshmati Beva owned and possessed A and C schedule and inherited 1/4 share from B schedule land, and remaining land got by the pro forma defendant number 1 to 3 after death of Muhammad Ali. That the defendant number 1 is the adopted daughter and the defendant number 2 is the daughter-in-law. Although it is written daughter-in-law, my lord, it ought to have been son-in-law of Keshmati Beva, lived with Keshmati Bibi and looked after the property of A and B schedule B land. And out of love and affection, said Keshmati gave 1 kotha 6 lesas to defendant number 2 and 3 kotha to defendant number 1. And the plaintiff inherited suit land after death of Keshmati Beva. Par contra, the defendants in the written statement pleaded that Keshmati Beva not owned 4 bigha 2 kotha 2 lesas and Muhammad Ali not left any land, and he gifted 5 bigha of land to the defendant number 1 by deed number so and so. The defendants further pleaded that late Saheb Ali died leaving 28 bigha 3 kotha 1 lesas, and he was survived by 4 sons, that is Muhammad Ali, Qasim Ali, Mujibur Rahman and Muslim Sheikh, and 2 daughters, namely Mohila Bibi and late Sahida Bibi. That Muhammad Ali and as 3 brothers got 5 bigha 3 kotha 12.5 lesas, but said Muhammad Ali sold 2 bigha 3 kotha to Sodan Esa and another such and such white sale number Iman, which is in excess of his share. From the pleadings of both sides, basically it appears that the plaintiffs are paying right title interest over the suit land, claiming ownership of one Keshmati Beva over the suit land, claiming that Keshmati is the wife of Muhammad Ali, got the suit land and who died issueless. It further reveals that the plaintiff claimed the defendant number 1 is adopted daughter of suit land, and due to love and affection, name of defendant number 1 recorded over 3 kotha of land, and defendant number 1 looked after the schedule A and B schedule land, and subsequently defendant number 1 denied to vacate the suit land. On contra, defendants claimed that the husband of Keshmati, namely Muhammad Ali, gifted 5 bigha of land to defendant number 1 by deed number so and so in the year 1951. Plaintiff side in this case, to prove their above contentions, examined as many as 8 witnesses and exhibited 10 numbers of documents. On contra, defendant side examined as many as 3 witnesses and exhibited 2 documents. I have carefully gone through the oral and documentary evidence of both sides, where it appears that PW1 in his initial testimony supported the entire averments of plaintiff and exhibited 10 number of documents. From cross-examination of PW1, it appears before the court that PW1 deposes that Saheb Ali was the father of late Muhammad Ali and said Saheb Ali died leaving 4 sons and 2 daughters. He cannot say whether Saheb Ali had left 28 bigha 3 kotha 1 lesas of land. He cannot say whether Muhammad Ali acquired any property by purchase, settlement or exchange. PW2 1 Habibur Rahman submitted his examination in chief through affidavit supporting the entire averments of the plaintiff. PW2 in his cross-examination testifies that he don't know where from Muhammad Ali got the suit land, and he can't say the boundary dark numbers of the suit land. From the oral and documentary evidences of the plaintiff side, it appears before the court Muhammad Ali is the husband of Keshmati Bibi and said Muhammad Ali and Keshmati Bibi died issueless. How, my lord, died issueless? That has not been discussed, my lord. Sure. It further is proved before the court that the defendant number 1 is the adopted daughter. I mean, how it is proved? Without any evidence, without any pleadings, my lord. Is the adopted daughter of late Muhammad Ali and Keshmati Bibi, and the plaintiffs are the brothers of late Keshmati Bibi. It is also revealed that after the death of Muhammad Ali, said Keshmati inherited the suit land and the name of Keshmati Bibi recorded over the suit land. The documentary evidence of plaintiff's side supported the averments of the plaintiff as per Exhibit 3, name of Muhammad Ali and Keshmati Beva recorded over Khatian number 74. In fact, the name of defendant number 1 is also there in Exhibit 3, that has not been considered. And Exhibit 4 shows that the name of Keshmati recorded over land of Patta number 108 under duct number 8213843, which is described in the suit A schedule of plaintiff. Exhibit 5 shows that the name of Keshmati recorded over duct number 1745, and exhibit shows the name of Keshmati recorded over schedule B land. As per Exhibit 7 and 8, it appears before the court that by such and such case number, prayer of defendant number 1 for mutation of a name over the suit line got cancelled, and against that order, no appeal preferred by the defendant. Exhibit 9 is one certified copy. So it's Exhibit 7. I'll come to the next parameter. To sum up the oral and documentary evidences of the plaintiff side, it appears that the suit B schedule land of the plaintiff originally owned and possessed by Muhammad Ali, who died on 4/5/2000, and after his death, Keshmati, being his wife, inherited 1/4 share, and the plaintiff, being her legal heirs, inherited the same, and remaining portions of land inherited by the brothers and sisters of Muhammad Ali. That defendants reside with Keshmati Beba in her residence and in Dag number 43 with an area of 1/6 lesas, and defendant number 2 looked after the suit A and schedule B of the property. A schedule of the plaintiff is owned and possessed by Keshmati Beba, along with the movable property, including land C schedule, who died on 27/10/2000, survived by her 2 daughters. It ought to have been 2 brothers and sisters, that is the plaintiffs. Plaintiff, being the only legal heirs of Keshmati Beba, inherited her property, and their name has been recorded duly over Schedule A and land by Exhibit 10. It further reveals that the suit B and C land owned and possessed by Keshmati Bibi, and after her death, present plaintiffs, being her brothers and sisters, inherited the same. It also appears that defendant number 1 is the adopted daughter of Keshmati, and her prayer for mutation of name over the Schedule A and B got rejected by appropriate authority by Exhibit 7 and 8. It further reveals that the defendants are possessing the suit land, and defendant number 1 looking after the suit land. And when the plaintiffs accept defendant to vacate the suit land, the defendants turned on death on the request of the plaintiffs. In the other hand side, defendant side examined as many as 3 witnesses and exhibited 2 documents. I have carefully gone through the oral and documentary evidence of the defendant side, where I find that DW1 submitted examination in chief to affidavit supporting the entire affirmance of written statement. DW1 in his cross-examination testifies that the suit land earlier belongs to their father, and the suit land is 28 bigha, and after the death of his father, suit land partition between his brothers and sisters. He further deposes that he don't know in whose name and the suit land is recorded. He further deposed that he doesn't know what has been written in the examination in chief. His brother Muhammad Ali got 4.5 bighas of land. Keshmati is the wife of Muhammad Ali. He don't read Exhibit A. Exhibit A and Exhibit B. DW1, being the defendant number 3 of this case, failed to support his own contentions to his cross-examination. DW3 even failed to say in whose name the suit land presently recorded. That shows that the defendant number 3 possesses no knowledge about the suit land. The documentary evidence of the defendant side says that Exhibit A is working Khatian 74 that indicates that the land earlier belonged to Sahib Ali, and on his death, the name of Muhammad Ali recorded in Khatian number 74, and Exhibit B is the rent receipts. The defendant side only proved one fact, that Muhammad Ali gifted 5 bighas of land under Khatian number 74 of Dag number 18 and 40 by deed number 2005 of 76 as per version of the DW3. But the defendant side failed to adduce any documentary evidence to prove deed number so and so. If we accept the testimony of DW3 that Muhammad Ali gifted 5 bighas of land under Khatian number 74 by give deed number so to Meherjan Bibi, that is the defendant number 1, even then that will not help the defendant side. In this case, defendant side failed to prove the fact that the Keshmati not owned 4 bigha 2 kotha 2 lesas, and Muhammad Ali not left any land. Rather, he sold and gifted by deed number so and so from Dag number 14, delivered possession to defendant number 1, and she is possessing the same. The defendant side also failed to prove that Muhammad Ali and 3 other brothers named above each got 5 bigha 3 kotha 12.5 lesas of land, and Muhammad Ali sold 2 bigha 3 kotha 15 lesas of land to Soda Nessa and another 5 bighas to Meherjan by deed number, which is the excess of his share. The defendant failed to produce any documentary evidence that can prove the fact that Muhammad Ali sold 2 bighas of land to Soda Nessa. More also, the defendant Meherjan Bibi, number 1, contested the suit by filing written statement to support, not contested the suit by filing written statement to support the case of defendant number 1, Qasim Ali. To sum up the oral and documentary evidence of the defendant side, it is apparently appears before the court the defendant side failed to prove their case. Therefore, in the light of the above discussion, I want to consider the opinion that the plaintiff side proved their case by establishing the plan. So, my lord, since I failed to prove the case, so the court is held that the plaintiffs have proved their case, my lord. Now, how Schedule A land was, my lord, possessed or owned by Keshmati Beba, absolutely no explanation, my lord. So, having held that, my lord, the issue number 5 and 12 was decided in the favor of the plaintiffs, that is the present respondents. And accordingly, the learned trial first appellate court has also affirmed this judgment, my lord, and held that any subsequent, my lord, sale deed that has been entered by Keshmati Beba or Muhammad Ali those are legal because we have failed to show that the defendants have failed to prove their case.
Okay, we will resume after 5 minutes.
Well. Discussion part, page 62.
Yes.
Page 62, second paragraph.
Hmm.
Now, after analyzing all evidences on record, it is clear that the claim of the plaintiff is based upon the land inherited from Keshmati Beva, who died issueless. It is not denied that Keshmati Beva was survived by her two brothers and two sisters, who were the plaintiffs in this case and only legal heirs of Keshmati Beva. Now, in respect of the story of the plaintiffs as to how the said land came to the Keshmati Beva is proved by exhibit, especially by exhibit 3, which is the final Khatian, and then exhibit 4 and 5, which shows that the land came to Keshmati Beva. On this point, defendant counterclaimant has a story that the land originally belonged to Sahib Ali, whose major son at the time of his death was Muhammad Ali. That Muhammad Ali, taking benefit of minority of the other children of Sahib Ali, got the whole land of Sahib Ali mutated in his name. But the defendant's counterclaimants could not prove this fact that the name of Muhammad Ali was recorded in respect of the suit land in fraudulent way. Hence, the subsequent transfers, this is important, my lord, hence the subsequent transfers made by Muhammad Ali cannot be said as illegal or inoperative. So, as there is no dispute that the plaintiffs are legal heirs of deceased Keshmati Beva and they claimed only property of Keshmati Beva, 63. Hence, it is clear that they have right title interest over the suit land on the same ground as it is not proved by the defendant, counterclaimant, that the land recorded in the name of Muhammad Ali was fraudulent. Hence, the subsequent made sale deed dated 11/3/1976 cannot be said as false. This sale deed is exhibit 9, my lord. There is no mention of this sale deed in the pleadings, my lord. Straight away in the evidence, they have brought this sale deed. Further, as Keshmati Beva was wife of Muhammad Ali, so she inherited the land of Muhammad Ali as per Mohammedan law of inheritance, and the same has been claimed by the plaintiffs. So the plaintiffs have 1/4 share in the Schedule B land also. As a result, the pro forma defendant number 1 has failed to prove that Muhammad Ali fraudulently recorded the suit land in his name, and pro forma defendant is not the survivor of Muhammad Ali. This is also, my lord, wrong, because pro forma defendant number 1 is brother of Muhammad Ali. So he is also one of the heir of Muhammad Ali as per Mohammedan law. So he cannot claim right title interest over the suit land. So at this stage of my discussion, I find that learned trial court rightly decided these issues. This point for determination, I decided accordingly. Now, my lord, in this discussion part, the learned appellate court has held that any subsequent transfer, that is exhibit 9, including exhibit 9, those are valid. Now, if I may take, my lord, to the Temporarily Settled Areas Tenancy Act, 1971, Section 8. How a land can be transferred by an occupancy tenant who has a Khatian in his name? 1971.
Some tenancy.
21. 1978.
1971.
Some land.
Land revenue regulation. Page number 63. Let me take up mine.
Assam Tenancy?
Assam Temporarily Settled Areas Tenancy Act, 1971.
'71.
71.
Okay.
Section 8.
Yes.
Right of transfer. An occupancy tenant shall have a right of transfer in respect of his holding with
Section
8.
Yes.
Right of transfer. An occupancy tenant shall have a right of transfer in respect of his holding with prior permission of the government in the manner prescribed. A notice of such transfer shall be served on the landlord in the manner prescribed, provided that an occupancy tenant shall not transfer his land to a non-agricultural. So, my lord, three conditions have to be satisfied. First condition is that, my lord, prior permission of the government has to be taken. Secondly, notice has to be given to the landlord that I'm transferring your land. And thirdly, my lord, it has to be transferred only to an agriculturist. Here, if my lord sees in the pleading of the plaintiffs, my lord, they have not mentioned that they have taken prior approval from the government, that they have served a notice to the landlord. In fact, they have not mentioned the name of the landlord, my lord. And that Keshmati Beva, she was an agriculturist. So all these three ingredients that is given in section 8, my lord, those were not complied. So in spite of that, my lord, learned trial court has held that any subsequent transfer made by Muhammad Ali, that is the Khatiyandar, that is legal and valid, without discussing this vital aspect of the matter, which goes to the root of the case, my lord. If now my lord takes up the document part, my lord, exhibit 3 are the relying, my lord, because the learned trial court as well as the appellate court has harped upon exhibit 3, my lord. Because exhibit 3, according to the courts below, my lord, shows the name of Keshmati Beva and Muhammad Ali. And as such, they have right title interest over the Schedule A and Schedule B plot of land. Exhibit 3, my lord, please.
Exhibit?
Exhibit 3. That is the Khatiyan number 74. The courts below have relied upon this document to show that my lord Keshmati Beva has right title interest because her name appears in the Khatiyan. If my lord sees first name is Muhammad Ali, that is the husband of. Second name, my lord, interestingly, defendant number 1, Meherzan Nisa, Pita Muhammad Ali. So this goes to show that, my lord, my father's name is Muhammad Ali. That is, my father is Muhammad Ali and my mother is Keshmati Beva, which they have alleged that, my lord, I am the adopted daughter. That is not correct, my lord. Because since they have failed to show or produce any documents or evidence that I am the adopted daughter, but exhibit 3 goes to show that my name appears in the Khatiyan and along with my name of my father is also there, my lord. So instead of relying upon this document to show that, my lord, I am not the adopted daughter and that I also have a share in the Schedule A or Schedule B property, the courts below have held to the contrary, my lord. These documents have been relied only to say that Keshmati Beva has got right title interest, whereas my name also appears along with my father and along with the name of my mother. This document has not been considered at all in a proper manner. And in the cross-examination part of PW code, that is the NDA, PW8, my lord, they have also stated that the name of Meherzan Bibi is there, showing the name of the father as Muhammad Ali.
Yes.
Now, my lord, has gone through the trial court judgment, whereas trial court has stated that since the PW1, he could not say the DAG number, patta number, or the revenue records under whose name the land is held. So, my lord, his evidence was not considered. I'll be reading the PW1 cross-examination part, my lord, where he has stated, my lord, he has got no knowledge as to the land belonging to Schedule A and Schedule B, under whose name it was, how it was inherited, how Keshmati Beva became the owner. Those things have not been considered at all. Cross-examination of PW1. Asiyat Ali. Mohammed Asiyat.
Yes.
Cross-examination. We are four brothers and sisters. We have filed this suit. Late Keshmati Beva was my younger sister. We have filed this suit for the properties left by late Keshmati. We claim 4.5 bighas of property of late Keshmati and 1 bigha from her husband Muhammad Ali. Saheb Ali was the father of late Muhammad Ali. Saheb Ali had 4 brothers. I cannot say whether daughter of Saheb Ali had not been made party, and I cannot say how many daughters Muhammad Ali has. He has not denied that my lord Muhammad Ali did not have daughter. He has stated that I cannot say how many daughter he has. That is my father, my lord. So that means, my lord, Muhammad Ali did not die issueless. I cannot say whether Saheb Ali had left 28 bigha 3 kotha 1 lesas of land at the time of his death at village. So Keshmati was the wife of Muhammad Ali. I cannot say whether Muhammad Ali acquired any property by purchase, settlement, or exchange. I know Saheb Ali died leaving 4 sons and 2 daughters. I do not know whether the land of Saheb Ali was inherited by his sons and daughters as per Mohammedan law of inheritance. I cannot say whether Muhammad Ali inherited any 6 bigha of land as the eldest son of Saheb Ali. It is not a fact that Muhammad Ali, being the eldest son, used to look after his father's property. I cannot say whether Saheb Ali is the tenant for the land measuring 28 bighas under Jotedar cities or Chandra Roy, Goripur Raj estate. I cannot say whether Muhammad Ali sold land measuring 2 bigha 3 kotha 15 lesas to Sadananda Saha and Badal Chandra Saha, and land measuring 3 kotha was sold to Soins. It is not a fact that the land measuring 5 bigha was sold to Meher Jan Bibi. Muhammad Ali was a grade 4 employee, Vidyapara Girls High School. It is not a fact that Qasim Ali used to plow the land of late Saheb Ali. It is not a fact that Muhammad Ali and his brother is residing in the old homestead of Saheb Ali. Meherzan is residing in the house where Muhammad Ali died. It is not a fact that Meherzan is residing in the house of Saheb Ali. It is not a fact that Meherzan Bibi is possessed also. I cannot say whether Meherzan Bibi, amongst other daughters of Saheb Ali, is alive. I have impleted all the legal errors. I cannot say whether this is Saheb Ali was the sister of. I have filed a suit for partition claiming the share of Keshmati and Muhammad Ali. It is not a fact that Muhammad Ali during his lifetime sold his entire share of land in favor of Sadananda Badal and Meherzan Bibi. It is not a fact that Keshmati did not acquire any. I cannot say whether land previous to the first settlement operation belonged to Saheb Ali. I cannot say anything about Exhibit 3. I cannot say anything about Exhibit 4, 5, and 6 were prepared. My father expired about 50 years back. So he has no knowledge about any of the documents. That is Exhibit 3, 4, 5, and 6, my lord. So interestingly, my lord, this aspect has not been considered, and he has not denied that Muhammad Ali did not die issueless. He has stated that I do not know how many issues Muhammad Ali had. Thereafter, if my lord comes to PW4, cross-examination part, he is the senior assistant RKG branch. He has also stated in his cross-examination
PW?
4. Hafizur Rahman.
Yes.
Second page I am taking, madam. Second. Khotian register mul 74 number Khotian dar hisabe prothome Muhammad Ali late Saheb Ali, that is my father, name as naam asil Utto Khotian Utto Muhammad Ali logot Muhammad Meherjan Nisa to Soharjan. Well, it is written as Soharjan, but it ought to have been Meherjan, daughter of Muhammad Ali, Keshmati Bewa, wife of Muhammad Ali, Mujibur Rahman, son of late Saheb Ali, Muslim Ali, so and so, Qasim Ali, that is the Prophet. So my name is also there, my mother's name is also there, my father's name is also there. In spite of that, my lord, the learned trial court has and appellate court has held that since Keshmati Bewa's name is there, she has got right title in there. But they have not considered this vital aspect that my name also appears and I also have got a share, my lord. Here it is clearly written, Muhammad Meherjan, daughter of Muhammad Ali. So I am the daughter, my lord. They have alleged that I am the adopted daughter. So burden is on them to prove and show that I am the adopted daughter, my lord. Whereas the exhibits and the documents are saying something else, my lord.
Yes.
Similar averments have been made in the cross-examination of PW8, my lord. PW8 is Abdul Khalik Pradhani. He is the lot mundal.
Yes.
A cross-examination is at internal page 3. I'm reading the second portion, my lord, just to show that my name is there and my father's name is also there. মূল জবাববন্দীত দেখা যায় যে পুৰণি 29 নম্বৰ পট্টাত নতুন 108 নম্বৰ পট্টাত 25 বিঘা 2 কঠা 1 লেচা জমিৰ পট্টাদাৰ ক্ৰমে Muhammad Ali, son of late Saheb Ali, second Muhammad Meherjan Nisa, daughter of Muhammad Ali. So my name appears in the exhibit 3 along with other documents and in the other documents, and always, as always, my lord, along with my name, my father's name is shown as Muhammad Ali. If my father is Muhammad Ali, then automatically my mother becomes my lord Keshmati Bewa, my lord, to whom they are claiming. If I have got a share, then they have got no share in the property. Hereafter, my lord, I'll be coming to a few decisions, 3 decisions I'll be relying, my lord. (2014) 2 SCC 269. This decision I'm relying on 2 points, my lord, that the plaintiff has to stand on his own feet to prove his case, and mutation entries does not confer any title. Paragraph number 15 to 18 I will rely. Paragraph 15, internal page 6.
Yes.
The legal position therefore is clear that the plaintiff in a suit for declaration of title and possession could succeed only on the strength of its own title, and that could be done only by adducing sufficient evidence to discharge the onus on it, irrespective of the question whether the defendants have proved their case or not. We are of the view that even if the title set up by the defendants is found against in the absence of establishment of plaintiff's own title, the plaintiff must be non-suited. 16. We notice that the trial court as well as the high courts, rather than examining that question in depth as to whether the plaintiffs have succeeded in establishing their title on the scheduled suit land, went on to examine in depth the weaknesses of the defendant's title. Defendant relied on the entries in the GLR and their possession or repossession over the suit land to non-suit the plaintiffs. The court went on to examine the correctness and the evidentiary value of the entries in the GLR in the context of the history and scope of Cantonment Act 1924, the Cantonment Land Administrative Rules so and so, and tried to establish that no reliance could be placed on the GLR. The question is not whether the GLR could be accepted or not. The question is whether the plaintiff could prove its title over the suit property in question. The entries in the GLR by themselves may not constitute title, but the question is whether the entries made in Exhibit A3 would confer title or not on the plaintiff. 17. This court in several judgments has held that the revenue records does not confer title. In Corporation of City of Bangalore versus M. Papaya and another held that it is firmly established that revenue records are not documents of title, and the question of interpretation of documents not being a document of title is not a question of law. In Guru so-and-so, the court has held that the entries in Jamabandi are not proof of title. In State versus so-and-so held that the entries in revenue papers by no stretch of imagination can form the basis for declaration of title in favor of the plaintiff. 18. The plaintiff has also maintained the stand that the predecessor in interest was the pattadar of the suit land. In a given case, the conferment of patta as such does not confer title. Reference may be made to so-and-so. So, my lord, the plaintiff has to stand on his own foot to seek a decree for declaration of right title interest. And merely because their name appears in the revenue records, that would not ipso facto show that they are the owners, they are having ownership over the plot of land, my lord. They have to produce certain documents such as my lord, sale deed or gift deed or my lord, will, at least some form of registered document has to be shown or through inheritance, my lord. Secondly, my lord, next judgment that I'm relying is my lord 2008-17 SCC 491. This is with regard to my lord Exhibit 9 that they have produced in the examination in chief, my lord. That is the sale deed in favor of the Keshmati Beva. Since there is no pleadings to that effect, my lord, that document could not have been relied upon by the learned trial courts, my lord. Paragraph number 11, I am relying, my lord. Internal page 5 are be taken. Paragraph number 11. I'm not reading the whole paragraph, it's a long paragraph. Paragraph number 11, next page, my lord, page number 5, first paragraph. It is well settled. My lord is wrong. It is well settled that in absence of pleading, evidence, if any, produced by the parties cannot be considered. It is also equally settled that no party should be permitted to travel beyond its pleading, and that all necessary and material facts should be pleaded by the party in support of the case set up by it. The object and the purpose of pleading is to enable the adversary party to know the case it has to meet. In order to have a fair trial, it is imperative that the party should state the essential materials facts so that the other party may not be taken up by surprise. The pleadings, however, should receive a liberal construction. No pedantic approach should be adopted to defeat justice on hair-splitting technicalities. So, sum and substance of the substance is, my lord, party cannot be allowed to travel beyond the pleadings, and no amount of evidence, if it is not pleaded, then it cannot be taken into consideration by the trial court or by any court, my lord. Thirdly, my lord, a decision of the Kerala High Court. Supposingly, my lord, if I admit also that I am the adopted daughter, as per their argument, my lord, that I am the adopted, then what would be the consequences of it, my lord? It is not that, my lord, under Muslim law, it is prohibited, but adoption is not recognized in Muslim law. Paragraph number 9 and 10, my lord. Para 9. Yeah, 1999, page 1. 1. Para 9. Mohammedan law also recognizes adoption if there is custom prevailing among Mohammedan communities. The custom is accepted to have the force of law as is held in AIA 1936 in Lahore. Section 29 of the Oud Estate Act 1869 permits a Mohammedan talukdar to adopt a son. In the state of Jammu and Kashmir also, the existence of local custom regarding adoption has been recognized. The right of couple to adopt a son is a constitutional right guaranteed under Article 21. The right of life includes those things which make life meaningful. Korea couple might have also thought of making their life more meaningful by adopting a son. Para 10. Thus, the Hindu law, Mohammedan law, and canon law recognize adoption. Therefore, simply because there is no separate statute providing adoption, it cannot be said that the adoption made by the Korea couple is invalid. Since the adopted son gets all the rights of a naturally born child, he is entitled to inherit the assets of George Korea couple. So it was held at my lord, adoption is also valid amongst the Muslim Hindu just as my lord as Hindu law, my lord. To security trust, my lord, I conclude my argument by saying, my lord, my appeal should be allowed, my lord. Since the decree was passed in respect of more plot of land recovery of possession, my lord, that is the first perversity that I'm seeking, my lord. Secondly, my lord, as I've already stated, with respect to schedule A plot of land, my lord, there is no whisper as to how Keshmati Deva became the owner of the plot of land. Thirdly, the adoption was not proved. On the contrary, my lord, the documents specifically directs to one point that I am the legal daughter of Keshmati Deva and Muhammad Ali. My lord. Fourthly, my lord, the sale deed that they have exhibited as Exhibit 9, that cannot be considered because that is beyond pleadings. And with regard to Exhibit 3, 4, 5, and 6, my lord, my name also appears. So if Keshmati Deva became owner of the plot of land only on the basis of exhibits, my lord, since my name is also there, so I'm also the owner, my lord. And since I'm anyways the daughter of Keshmati Deva, so after her death, all the property is devolved upon me. I'll just point to one last thing, my lord, I have forgotten. The plaint is not supported by affidavit, my lord. After the Salem Bar Association, my lord, decision and after the amendment, my lord, the plaint has to be supported by affidavit, my lord. That is, my lord, compulsory and mandatory, my lord. Only verification would not suffice. My lord.
Yes, madam.
Makes your lordship.
Mr. Iqbal, please give a written synopsis of argument,
My lord.
highlighting the points you have raised.
May I start now or lordship at 2 lordship? Only 10 minutes.
Yes, only 10 minutes time.
Lordship. May I
Okay.
start at 2
Two.
lordship?
We have some other matters after that matter.
Okay, lordship. VC is there or lordship? Two things.
हाँ, नहीं नहीं तू डालते हैं इसको डालते हैं पहले क्या हुआ?
Item 13.
Okay.
May I please your lordship? Can matter taken up in any other day, lordship? Today I'm not feeling well actually.
Lordship, on last occasion also they took time, so the last chance may be given and the.
No, I have no objection in any other day because only because of I'm feeling irritation in my throat, lordship.
Your good name, please.
Lordship,
Your name, please.
Deva Sharma.
Heard Mr. Deva Sharma, learned counsel for the appellant, and Ms. R.S. Odori, learned counsel for the respondent. Ms. Sharma submits that he is not feeling well and tries for listing the matter on any other date. Pair is allowed to list the matter on
12th November, lordship, it's a Tuesday.
12th, not possible.
26 November.
And 19th November, lordship,
19th.
third week of November.
Okay, we'll try.
Lordship, deeply obliged.
Highly obliged.
Item 15.
May it please your lordship. This matter may be adjourned for the day. My senior is out of station.
Who is your senior?
He had to go to Morigao.
What is his name?
M.A. Sheikh, advocate.
In this matter, my lord. On last occasion also, my lord, this honorable court is considering the matter, consider fix this today, even no intimation to prior that he is not available today. So lordship, by due permission, I like to make my submission today. Let them fix another.
No, not in a piecemeal manner. Because he has to answer to your
Yes.
points.
Then, my lord, then next Tuesday can be fixed, my lord. That is my
Short-
humble
short
submission.
date may
Next
be fixed.
Tuesday can be, my lord.
That will be all right.
No, this matter is relatively new, 21 matter.
Yes, my lord, my some urgency considering this honorable court, my lord.
Urgency.
Yes, my lord. All of this honorable court is recorded, my lord. My only humble submission, my lord, can it be on 29th?
No. Before this Diwali, we cannot take up.
Then, my lord, on 5th
Already
of,
picked
5th of
up.
November, kindly, my lord. 5th of November, kindly.
14 November.
Hello. 12th November, my lord. 14th, I have some, my lord, for 12th November.
12.
Yes.
Okay, on the pair being made by Mr. Your good name, please.
W.A. Sheikh on behalf of
W.A.
Mr.
Sheikh,
M.
learned counsel, appearing on behalf of Mr. M.S. Sheikh, learned counsel for the respondent. With consent from the other side, list the matter on 14th or 12th November.
my lord. Diplomatist.
What's up, lord?
1920.
Your lordship,
Hmm.
in item number 20, I am the review petitioner. That may be withdrawn because that petition has become infructuous.
Item number
20.
20.
Review petition 128 of 22.
Miss, your good name, please.
MST Das.
MST does learned counsel for the petitioner. Heard Miss T does learned counsel for the petitioner and Miss
Yes, sir.
S. Sharma learned counsel for the respondent. Ms. T does learned counsel for the petitioner submits that this matter become infectious and she may be permitted to withdraw the same. Accordingly, this review petition is disposed of on withdrawal. Next matter.
19.
In item number 19.
19. I am for 19. Petitioner. I am the petitioner in item number 19, Your Lordship.
Yes.
Your Honor, in this also I have a simple submission. In this, the title suit is in final stage. All the evidences have been taken over. Now it's for argument. It is fixed on December 6th. So if it's allowed, if this impugned order is allowed, then there is no delay for them.
Your Lordship, what is the problem in hearing and deciding the main issue that we have raised in this petition, Your Lordship? It is not going to affect their title suit at all.
Your Lordship, the thing is that if the temporary injunction is granted till the disposal of the suit, title suit, it is not going to affect them because it is already in the final stage. Next date is for argument and then it will be for the judgment and order.
Your Lordship, what happened in this case, the petitioner is the widow of the joint of the person who is a joint owner of an ancestral plot of land. And the respondents have already constructed an RCC building over it. But this petitioner is a widow who has no means to construct a house for her own. And that's why she has applied for issuance of a house under the Pradhan Mantri Awas Yojana, which has been allotted by the government to her. But their issue is that she has no right to construct her house over that plot of land. Standing there, she has no right. But in their own title suit, Your Lordship, that is title suit number 6, standing before the Civil Judge Senior Division, they themselves stated that they have constructed an RCC building over the plot of land. But they are hiding the fact that there has been a family settlement between the two brothers. Otherwise, how they have constructed a building over the plot of land without any partition order? They have constructed their part. But now when I want to construct only a simple house under the Pradhan Mantri Awas Yojana, they have done objection, Your Lordship. That is palpably, Your Lordship, before clear that there must have been a family settlement. Otherwise, how they have constructed their house over the plot of land without any partition order?
But when I'm trying to construct a little house, they are raising the objection. Your Lordship, kindly go through my review petition 36 and title,
No,
title should.
Against which order this review petition is filed?
Your
Order
Lordship,
dated 9/6/2022?
yes, Your Lordship.
So your prayer is to vacate this status quo order.
Yes, Your Lordship. Because my, the government has issued me a Pradhan Mantri Awas Yojana, and I have every right to construct. And the thing is that, Your Lordship, if I suppose construct the house, then if I am not entitled to, then it may be devastated at any moment. But when then, who will suffer the loss? The government, because it is the money of the government. But they have not even made government a party to the suit, Your Lordship. So the injunction order is given only when there is palpable loss to the petitioner. But where then the loss to goes to them, Your Lordship, if my house is demolished. Your Lordship, kindly, I see page number 51 of the review petition, Your Lordship. I would like to draw your attention to the observation of the learned civil just senior division of the Your Lordship. The last, just the last paragraph, just above the last paragraph, it is clear that the plaintiff has his RCC building standing over the asset. It is not clear whether the plaintiff has constructed the plaintiff, that means the present respondent, Your Lordship, constructed the RCC building over the asset, suit land, when the suit land is still joint property, as claimed by the plaintiff after taking NOC from the principal defendant or not. If the plaintiff has not constructed his RCC building over the undivided suit land as claimed by the plaintiff with NOC of the principal defendant, then why is the plaintiff objecting when the principal defendant has bought a house from the government and wants to construct the same over the suit land when she has equal share over the suit land? That is very much clear observation, Your Lordship. So there is nothing in this case to grant them injunction, Your Lordship.
Yes, madam, what is your submission?
Your Lordship, the para she has stated regarding the NOC, that is a matter of fact and which has come into light while taking the evidences of the official witnesses. The LCR, the whole LCR is not here. The evidences of the official witnesses have already been taken and they have stated that there was no partition. So, and moreover. That is the thing, Your Lordship. If there is no partition, then how they constructed their RCC building? I'm replying to this, Your Honor, Your Lordship, if she allows me. The thing is that while constructing, it's not a building, it's just a simple house. There was a written mistake in my. But nowhere, Your Lordship, there has been number of plans by them. So starting from the title shoot, then the injunction petition, then the FAO before the court, nowhere they have stated it's a simple set. Everywhere it is a RCC building, Your Lordship. Your Lordship, if I may be permitted. Your Lordship, the thing is that that is a simple typical mistake which is written as building. It is only just an RCC house, and for that we have taken the permission from the Bilasipara Municipality Corporation, and that thing has come out in light in evidences of the official witnesses. And without taking no objection.
One by one. First, let her complete.
And without taking no objection, if we have constructed that, she should have objected us, but heard no objection was taken, and then we applied to the Bilasipara Municipal Corporation. And here what happened, Your Lordship? The thing she is saying that they have taken, the defendant has taken PMAY, Pradhan Mantri Awas Yojana. There she has to submit a NOC that the respondent has no objection if any house is constructed over the land. But what she did, she herself put the sign and she made the affidavit and she has presented to the government, which is very much clear from our petition. When Lordship, if it is so, then it's a criminal matter in nature. Then it is their duty to prove my guilt that I have done something like that, and they should go for an FIR or before the criminal court, Your Lordship, and not to harass me in this way, in a very palpable right of mine.
Yes.
And, for,
Complete.
and even if you suppose, Your Lordship, it is very much clear that I have a right. And this is a joint property, and this is not only according to me, this is according to them also, starting from their title suit everywhere. And Your Lordship, if they can construct their part, then I have also right to construct a little house on my own part. That is very much clear, Your Lordship. And it is a joint ancestral property, Your Lordship. That cannot be denied at all.
Okay.
My lord, in your plaint, we have clearly stated it is the, my lord, joint property, but no partition is there. And what happened? The original plaintiff is a government servant who was residing at Guwahati. And when he was residing in Guwahati, she has, the now petitioner, she has filed one affidavit, forged affidavit, putting signature of this Dhirendranath Das, and obtained the scheme. And it came to light that she has taken forged signature by putting up my signature. And moreover, the original, there was my lord, two rooms which was used by me, and another 2 rooms which was used by that person. Then what she has done, she has destroyed my room and the belongings has been put outside. And my lord, permission has been taken under PNG Housing Yojana on that portion. That is our objection. And that is why in the plaintiff we also stated, and in the evidence also, she has clearly stated, in cross, she has already stated regarding my lord, forced signature of affidavit, that is silent in the written statement, but in cross, all thing has been stated. And now in the next date matter, it is for argument, that title suit. So at this stage, my lord, as there is a, my lord, controversy regarding right title and my lord position.
No, it is
So-
joint property.
Yes,
She
joint
has also equally,
Yes.
she has also the
Equal
same
right.
right with
Equal right.
which
But-
you have.
Yes, I also accepted, and I in my plaint I have also stated that. But that is the position which portion was in my 2 rooms that has been destroyed, and forged signature has been given. That is the question mark.
No, that is not the issue before this court.
Their course is whether it is joint property. That is one question. Whether he has taken the permission from the my lord authority by proper means. When we have complained to the town committee has also suspended that my lord scheme. At this stage, she is not getting any money, which was disbursed earlier. That is okay, my lord. Now, my lord, in the next date, that is my lord 3rd December, I think, that is the for hearing. Title suit. 6th December for argument. I am not denying his right. I am also stating yes, she has right. But what process he has taken,
and the destroying of these two rooms, which I usually to stay there when I went there, my lord. So that is the, my lord, capturing of position. Right does not mean, my lord, I take by the position of one person by destroying my room. She is right. Surely she is right. And in title suit also I have stated that.
But actually, all these pleadings does not change the fact that I have a right over this plot of land. And they have constructed their RCC building over their plot of land. And how there can be a typographical mistake continuously, starting from the title suit, then an injunction petition, then a FAO before this honorable court, then before and review their own review petition, then this review petition, your lordship, in all their affidavits, how there can be continuously a typographical mistake. And even in the order of the civil judge senior division, then why they have not applied for the ratification of the judgment, your lordship? Your lordship, that's why I humbly submit, your lordship.
Okay, okay, we will pass the order.
Highly obliged, your lordship.
One thing, the statement in the cross, which she has given, if your lordship goes to
You furnish the court master, we will say.
So all criminal in nature, if there's something like that, they can go to the criminal court.
Your lordship, already FIR has been lodged regarding that.
No, only senior can submit, not by you. Huh? See again. We'll pass the order. You submit that cross-examination portion to the court master.
Because there is an amendment which is introduced in 2015. So the appeal lies before this honorable court only, before this honorable high court. So the lordship may direct the registry to convert it to the appeal. Because in refusing the appeal is lies if it's accept then 227.
Is there any bar in registering the revision petition as appeal? No bar.
Nothing. Only one difficulty, my lord, there is a prescribed form for filing the appeal, my lord. And my lord, that form is not there because in this petition it is written like a writ petition, no grounds mentioned, my lord. And my lord, nowadays arbitration proceedings.
By a judicial order, that can be because
Better you do one thing, you withdraw it. You file the amended this in the prescribed format.
Because it is within the period of limitation, because he has to do the e-filing, my lord. Now all arbitration proceeding is to be first by the e-filing, my lord. E-filing is mandatory, my lord.
Okay.
the certificate copy may return back. The certificate copy we have filed here.
Yes.
That may be returned.
Okay. Heard Mr. B. Dutta, learned senior counsel, assisted by Mr. S. Deka, learned counsel for the petitioner, and Mr. A.K. Gupta, learned counsel for the respondent.
1 and 2, my lord.
Respondent number 1 and 2. Mr. Dutta, learned counsel for the petitioner, submits that he may be allowed to withdraw this petition and with a liberty to approach this court again by filing appropriate petition. There is accordingly allowed. This CRPIO is disposed of on withdrawal. Rest is directed to return the certificate copy of the documents filed by the petitioner along with this petition.
Careful.
Pending item number 1.
Here in this case, lordship, basically we are challenging the remand order that has been passed.
on the ground with regard to the maintainability which was indicated by the defendant. And the court, the lower appellate court, remanded the matter only on the point of the deciding the issue of maintainability of the suit. Now this, the trial court order, the lower appellate court order is at page number 30, Lordship. Page number 30 মানে first page, first page. Page number 30, Lordship. Is a lower appellate court judgment in order. In that particular this operative portion, because in first few pages with regard to the facts of the case. Now the issue is at page number 34, Lordship.
Yes.
Page number 34, the four issues, the five issues are framed. Basically, the two issues with regard to the barred by law of adverse possession, which the plaintiff has any rightly interest over the suit length. Now, when deciding all the issues, Lordship, lower appellate court, I'm just reading this relevant paragraph, Lordship, this last paragraph of page number 34. The gist of the memo which is that the trial court erred in law as well as in facts in declaring the suit. As such, the impugned judgment in decree are liable to be set aside. The trial court failed to consider the evidence on record in its true perspective while deciding the issues and have come to an erroneous finding, and as such, the finding and decree that the judgment and decree is valid in law and facts. The trial court erred in deciding issue number 3. The trial court ought to have decided issue number 2 in favor of the appellant and defendant, holding that the suit was barred by law of adverse possession on the point of limitation that the decision of issue number 1 and 4 is based on the decision of issue number 2 and 3, which themselves are not properly decided, and hence the decision on those issues are not tenable in law and facts. Learned counsel further admitted the trial court failed to consider that the PW2 was an employee working as chowkidar and residing on the land and house of the plaintiff respondents. Hence, he was a highly interested person, and the said witness was also an illiterate person. That the trial court ought to have held the non-taking of action under the criminal law or under the civil law for restraining the encroachers from constructing any house or sufficient and presume that no such encroachment was made on the day as alleged that from the materials on record, the trial court ought to have dismissed the suit, holding the plaintiff failed to prove their case, that in view of the matter, the impugned judgment and decree is not tenable in law and facts and liable to be set aside. Peruse the memo paper and the case record. I have heard the learned counsel for both sides. Learned counsel for the appellant has submitted that the trial court ignored the written statement filed by the defendant and appellant in respect of maintainability of suit. The trial court did not frame any issue in this manner, such as whether the suit is maintainable in law and fact, which causes prejudice to the appellant defendant. From the above, it is arbitrary, abundantly clear the non-framing of issue to the effect as to whether the suit is maintainable in law and on facts cause serious prejudice to the defendant appellant. The inference gets strengthened when I find that the defendant appellant could have led their evidence separately to prove the aforementioned issues. The court holds the trial court ought to have framed as well as discuss the issue in regard to maintainability suit, as the same is the most vital as well as important issue in the suit. Further, when there was strictly speaking no aforementioned issue before the learned trial court, question of adducing evidence in this regard did not arise at all. It is also important to note that if the main contention of the parties in the suit is not discussed in the judgment, it caused serious prejudice to the parties. Non-framing of proper issues and skipping to discuss the averments made in by the parties do not reflect the cases of the contending parties, and as such, the entire suit suffers from severe prejudice. Under the discussion made above, I am firmly in the view that suits needs to be remanded to the learned trial court with the issue be framed and decided on following aspect of the matter whether the suit is maintainable. This court holds that the aforementioned issue relates to both law and fact, hence better justice could be served by the parties. The trial could decide the earlier issues after hearing fresh argument for both sides. So only on the point of the written statement, that particular issue was not framed, and in the written statement they have raised this objection with regard to the maintainability of the suit. With regard to that, lordship, this entire matter was remanded back. Now the ground that you have taken, lordships, the first ground is with regard to order 41 rule 24. Order 41 rule 24 with regard to the when there is absolute all the materials are before the court below, before the learned lower appellate court. The learned lower appellate court has the authority and the jurisdiction to reappreciate all the materials available on record, but that was not done. Now, while with regard to the fact the maintainability of the suit,
because why it is not maintainable, they have raised the issue in the written statement. Now this point with regard to the barred by law of adverse possession and the plaintiff has right title interest over the suit land. These particular two issue, Lordship 2 and 3, would cover this maintainability of the suit. But the learned lower appellate court has not taken note of that aspect of the matter. If your Lordship kindly see their written statement as well as the plaint. In the plaint, Lordship, this at page number 5. In paragraph number 3, the cause of action has been discussed. Paragraph number 3. Paragraph number 3 does mention that subsequently on or about 16/6/1992, the defendant forcibly encroached upon and occupied approximately 2 acres of land described in the schedule hereto below, and the suit land forming a part of the land of Dag number 493 situated just adjoining the municipal drain, and hurriedly started raising a temporary shed with CI sheets and bamboo posts and bamboo walls measuring 25, 24 and 12 inches approximately just behind the aforesaid temporary gumti. The plaintiff through their employees protested against such illegal and unauthorized construction on the plaintiff's aforesaid plot of land, but the defendant, while abusing the plaintiffs in filthy languages, threatened the employee with dire consequences, forbidding them not to obstruct or interfere with the construction raised by the defendant. The plaintiff therefore apprehends breach of peace, restrained their employees. Subsequently, the defendant completed the construction of the said temporary shed and shifted the farm shop to the said temporary and removing the gumti from the original place, and also started to reside in a part thereof with his family. That even in spite of repeated demands and requests, the defendant did not remove the said temporary shed constructed unauthorizedly. The plaintiff therefore on 18/9/1993, through their advocates, the Archive Bhattacharya Dibrugarh, sent a notice to registered post to the defendant, asking him to vacate the said plot of land by removing the temporary shed constructed illegally by him thereon on or before 31st October 1993. The defendant, though duly received the said notice, neither replied to it or not vacated the said plot of land described in the schedule below, and thus withholding possession thereof from the plaintiff. The copy of the said notice shall be received by 5 years. So basic contention of the plaintiff was with regard to the illegal possession over the suit land. Now they have raised the issue of maintainability. Now that maintainability aspect of the matter can be dealt with, and accordingly the issues are framed with regard to the right to interest of the plaintiffs, as I've just now pointed out, Lordship, in the lower appellate court, with regard to the right to interest of the plaintiff over the suit land and whether they're entitled for recovery of cash possession. Now these two aspects of the matter would cover the contention that has been raised by the defendant with regard to the maintainability of the suit. Now how they are raising the maintainability, Lordship, I'm just placing that aspect, Lordship, in the written statement. Written statement, Lordship, in page number 10. Page number 10. Only one paragraph, one line, Lordship. In paragraph number 3. In paragraph number 3, they mentioned about the suit is not maintainable in law and form, but they have not discussed anything with regard to how it is not maintainable in law and form. And that is the reason why, Lordship, in the lower appellate court, when the judgment and the impugned judgment and order was passed, with regard to that, the learned lower appellate court has not framed any issue how this particular suit is not maintainable, under which provision of law this particular suit is not maintainable. Merely a statement is there with regard to the fact that the issue has been, additional issue has been framed that the suit is not maintainable. Now the maintainability of the suit can be taken into account with regard to the issues that was framed by the learned lower court, Lordship. The barred by law of adverse possession. Now the law of adverse possession, if it is barred, then the suit is not maintainable. If this particular issue is taken into account by the lower court or the lower appellate court, then the suit is not maintainable. If the written statement or the evidence of the defendant side can establish the fact that this particular suit is not maintainable, then this will cover the maintainability of the suit. So my only prayer with regard to the fact that the lower appellate court was having the jurisdiction to decide or to adjudicate on the point that was taken into account by the lower court, because all the evidence was there. The lower appellate court can take note of all the evidence of the pleaded facts and the documents exhibited before the trial court. So the remand, the order that has been passed, this is absolutely perverse, and there is no reason, because nothing has been mentioned in framing the additional issue how it is not maintainable. Because the maintainability point, they have also not agitated anything in the written statement, only one line, it is not maintainable in law and form. They have not expressed anything how it is not maintainable. And the maintainability part can be taken into account with regard to the issue that was framed by the lower court, as well as dealt with by the lower appellate court, with regard to the fact that this suit is not maintainable in law and form. Now, the adverse possession issue was there before the learned lower court as well as before the learned lower appellate court. So this will cover the maintainability part of the suit notion. So my prayer is that since the matter was taken into account by the lower appellate court, so instead of remanding back to the trial court, because this will drag the matter for another few years, this lower appellate court, since all the documents, all evidence and everything is there, can decide on the appeal and accordingly pass necessary order with regard to that instead of remanding back to the trial court, lordship. And that is the reason why, lordship, we have taken the grounds. The first ground with regard to the order 41 rule 24. Because order 41 rule 24 is very much clear with regard to the fact. Order 41 rule 24 is very much clear with regard to the fact that the court, while remanding the matter, must arrive at a finding that the records or the documents which are there are not sufficient to adjudicate the issue or they decide on the points that was raised before the lower court. So since all the materials were there, the evidence, documents, exhibited documents, everything was there, it is sufficient to decide the point of order 41 rule 24, lordship. So this relevant aspect of the matter was not taken into account by the lower appellate court, and this erroneously this passed the order, thereby remanding the matter to take a fresh decision with regard to that. I'm just referring to order 41 rule 24, lordship. As you kindly see the order 41 over 24, where the evidence upon the record is sufficient to enable the appellate court to pronounce judgment, the appellate court may, after resettling the issue, if necessary, finally determine the suit, notwithstanding that the judgment of the court from whose decree the appeal is preferred has proceeded wholly upon some ground other than which the appellate court proceeds. So it's absolutely clear, lordship, order 41 rule 24. But all materials are there before the lower appellate court. Lower appellate court can pronounce a judgment based on all the materials available in the record. And it is also not clear from the written statement how it is not maintainable. Now the maintainability part would come into play only with regard to the adverse possession. Now the issue of adverse possession is there, and the learned trial court has adjudicated the issue with regard to adverse possession in issue number 3, lordship. Now it's lower court judgment, lordship, which is page number 15. I'm just referring without taking much time, lordship. It's page number 15, page number 17. Adverse possession, the issue is issue number 2, lordship. And accordingly, issue number 2 has been properly dealt with by the learned lower court, lordship, at page number 20. With regard to the whether the suit is barred by law of adverse possession. Since that aspect of the matter has been dealt with, there is no reason of remanding it back to the lower court for taking a fresh decision. My humble prayer, this matter may be, this appeal may be allowed, setting aside the input judgment and order, and accordingly giving a direction to the lower appellate court to pronounce the judgment on the basis of the materials available on record within a stipulated period of time.
Yes, doctor.
What I feel my learned friend is not that way very incorrect. My lord, the appellate court, let the appellate court frame this issue.
Yes.
So for the maintainability question is it is there, because we have taken that point. They have said we haven't taken with so much of languages. But then ultimately that point remains. And your lordship will find in the evidence on record that I have been in possession of the land for more than 25 years. So I have acquired that right. So all the materials are there available. So let the appellate forum by issuing that particular maintainability question, he can decide himself also.
No,
For the not apprehension in the mind of my learned friend, if it goes back to the trial court, it may take more time, because against that order, either side may come in appeal before the appellate authority. So therefore, some time can be saved.
No, the question is whether the materials already before the trial court is sufficient to, no. Already brought on record by the learned trial court is sufficient to decide that issue.
The evidence.
The issue of maintainability by the first appellate court.
That will be the question the appellate forum may find some difficulty. It has to be decided with the trial court. Because the question of the adducing evidence may also come. Whenever some new issues will be framed, in certain point of time, the question of reducing evidence will come. So it will be better placed if it goes before the trial court. But ultimately, that question has not been decided by the appellate court also. The question of adverse position is there. The trial court did not decide. And the evidence of the plaintiff is one, he is Chowkidar, who is much interested. So those questions are there.
Then suggest the best course. Should we remand it to?
Let it go to the trial court. Your lordship can give some time frame. So within 3 months, that will have to be decided, although it is very difficult. Because from our experience, we have seen. Even
No, nowadays we cannot direct, we cannot frame the time. In view of judgment of Supreme Court in the case of Allahabad, Bar Association Allahabad and State of UP.
Yes.
Such kind of direction not permissible now.
Now, lordship,
Thereafter also, after that judgment also, one of the High Court has given direction. Supreme Court has reprimanded the High Court.
Exactly, because those sort of direction is quite unnecessary. We have seen 3 months direction is given, even within 3 years you can't decide it. It is impossible.
Impossible to some extent.
So therefore, my lord, expeditious disposal your lordship may say.
lordship, kindly see the impugned judgment and order. In the impugned judgment and order, there is no specification with regard to the fact that what is the legal procedure under which the suit is barred. Because the only legal requirement is that the suit is barred because of the adverse possession. Because this is the only legal requirement by which the suit can be barred. Because it has not been clarified by the trial court, in the written statement, as well as in the judgment of the lower court, lordship, lower appellate court. So in that view of the matter, there is no finding with regard to the fact. That is the reason why I referred to order 41 rule 24. Because before remanding, if your lordship kindly see, I am just reading it.
Not bargaining, my lord. I am keeping everything before your
But
lordship.
the evidence on record upon the
The lordships feel it is to go to the trial court, it's up to your lordships. But what I feel, when you frame a new issue, there will, the question will come whether both the side is required to give fresh evidence or not. So in that case, my lord, if it goes to the trial court, they will be in a better position to give the evidence in the trial court.
Yes.
lordship, what I am submitting, because order 41 rule 24 is very much clear with regard to the fact that whether evidence upon the record is sufficient to enable the appellate court to pronounce judgment, the appellate court.
No, that's why I am putting the question to you.
Exactly, lordship.
Whether
now the
materials
maintainability
before the court is sufficient
Exactly,
to
lordship.
decide that issue, maintainability issue.
Because the point of maintainability has been raised by the defendant by just one line. This suit is not maintainable. What is the legal proposition? What is the legal embargo with regard to the maintainability of the suit? Now, the only legal embargo is that the defendant is claiming that I am in possession of the land for such a long period of time.
To determine that point, we have to
No,
peruse
lordship,
the
there is no
entire
counterclaim.
written
No,
statement.
lordship, there is no counterclaim on the part of the defendant. Now, with regard to the point of adverse possession, there should be some claim. There is no claim with regard to that. There is no counterclaim that I am in possession. I am also entitled for the declaration of right to interest.
I don't want to take to all that thing. My lord, if your lordship look at the DW1 evidence is very clear. He has been staying
Yes.
there for more
Then,
than 25
if the evidence is clear, lordship, all the materials are there before the lower appellate court to adjudicate the issue of
Why not
maintainability of the
it
suit.
should go back to the trial court? Why
Because this is-
unnecessarily we are bargaining for all that?
No, what my learned senior friend is saying about this DW1 is very much
You are
clear.
in a better case.
Yes, then DW1 is clear. And all the evidence is before this lower appellate court to adjudicate
I
the issue.
leave up to your lordship.
Okay, I will go through it and pass the order.
Yes, lordship.
Your lordship, can you see the evidence of DW1 also?
Always.
Much of it.
We are disposing of it.
Yes,
Yes,
lordship.
yes.
The old pending matter, lordship.
Standing item 11.
Please, Your Lordship. Lordship, the first objection as raised by my learned friend that there was mismatch in the order right title declaration and the eviction part, Lordship. in the order itself.
Mm.
First of all, your lordship, the plaint which shows the schedules, lordship,
Mm.
page 10 of the appeal memo. Internal page 5, lordship. In fact, this is a partition suit, lordship. We are being the brothers of the deceased. We claim the properties left by my sister from her father as well as from her husband, lordship. Page 10, lordship.
Yes.
Amended part is also included in this page also, lordship. And amended plaint also they have enclosed, that is page 26. I'm reading from page 10, lordship. That the plaintiff therefore claims and prays for a decree declaring title of the plaintiff over the land of Schedule A and B by Mohammedan law of inheritance. That was amended, lordship. A decree declaring that the title of the plaintiff over the entire land of Schedule A and over 1/4 part of the land of Schedule B and thereafter AA. Is it there in the page 10, lordship?
Mm.
A decree declaring that defendant number 3 and pro forma defendants do not have title over more than 3/4 part of the land of Schedule B. So, lordship, Schedule B, there is a mention of 3/4 part and 1/4 part and the entire land, lordship. So their claim is that right title interest over 1/4 part of the Schedule B, as because they are only entitled for 1/4 part of the Schedule B land. That is the land inherited by the sister from her husband. So when a Mohammedan wife is widow, her entitlement is only 1/4 when there is no issue. And if she has an issue, lordship, had it been a case that she is with her children, her share would have been 1/8, lordship. But in this case, as there was no issue left by Muhammad Ali and Kaismati Beva, so she is entitled for only 1/4. The rest 3/4 part will go to the defendants, lordship, being the brothers of late Muhammad Ali, her husband, lordship. So they claim their right title over only 1/4 part, lordship. They cannot claim right title over the entire 3/4 or entire B schedule land. But recovery portion, they have mentioned that decree of khas possession for recovery of the land of Schedule A and B, evicting the defendants, their legal heirs and agents, lordship. Now, your lordship, kindly see Schedule B. Situated in village Borobila Part 1 under Circle Dhubri, land measuring 4 bigha 1 katha 6 lesser. Recorded in the name of Muhammad Ali under Dag number so-and-so, out of which 1/4 share of Kaismati Beva. So even if there is a decree for eviction of Schedule B, our entitlement is only 1/4. That is clearly mentioned in Schedule B, lordship. So as my learned friend has pointed out that declaration, right title interest declared only over 1/4 and eviction of entire B schedule was given. That is not correct, lordship. Her share was clearly mentioned, 1/4 share of Kaismati Beva, that is 1 bigha 0 katha 6.5 lesser. Rest part will go to the defendants, lordship. So this is a plot, lordship, inherited by late Kaismati Beva through her husband. Earlier, the suit was filed by the plaintiff's, lordship.
Yes.
Earlier, the suit was filed by the plaintiff 1, 2, 3, 4 against Meherjan Bibi, that is the adopted daughter, Faizar Ali, defendant number 2, husband of adopted daughter, which was mistakenly written as daughter-in-law, Lordship. And pro forma defendant was made Muhammad Kasem Ali. He is the brother of husband of Kaismati Bewa. Property belongs to one Kaismati Bewa through from her father and through her husband, Lordship. Now, your Lordship, page 2, your Lordship, kindly see legal heirs of late Muslim Ali. Muslim Ali is also one of the brother of Kasem Ali. So his legal heirs also made party A, B, C, D, E, F. As because Kaismati Bewa is inheriting her husband's property, 1/4 only she will take, rest 3/4 will go to the other brothers of her husband, Lordship. So there are some other brothers also, they are Muslim Ali, his legal heirs were made parties, and Muhammad Mohia Bibi, that is number 3, Lordship. And plaint was later on amended, all parties were implemented, Lordship. But only defendant number 1 filed written statement and counterclaim. That is page 13. Your Lordship will find that written statement of pro forma defendant number 1. At the beginning, the Kasem Ali was pro forma defendant number 1. When he contested the suit by filing written statement and counterclaim, he was made main defendant number 3. Lordship will find that the written statement by pro forma defendant number 1 only, but the trial court judgment says written statement filed by Meherjan Bibi as her signature is only on the first page of the written statement. Thumb impression, Lordship. That is RTI of Meherjan Bibi. But nowhere in the written statement, not a single line was Lordship pleaded by the Meherjan Bibi. Written statement of pro forma defendant number 1. And the counterclaim portion, the prayer portion, I'll take your Lordships. That is real facts also, the defendant is stating that the plots, lands which were mentioned in Schedule B are the lands of Muhammad Ali, inherited from his father, Muslim Ali. Sahib Ali. And para 25, they have mentioned that counterclaim portion, Lordship. Page 18, internal page is 6, Lordship. That the pro forma defendant number 1 also files counterclaim for issuing permanent injunction against the plaintiffs from taking possession of the suit land by dispossessing the pro forma defendant from the suit land shown in the plaint and for declaration of right title of the suit land. Now, Lordship, paragraph 26, he mentioned the entire Schedule A land. That the pro forma defendant further pray for deleting the name of Kasmati Bewa, alias tenant under Muhammad Ali for land shown in Schedule A of the plaint, being Dag number these. So his Lordship prayer is also including Schedule A. That the cause of action of the suit arose the date of filing of the suit on April 2001 and thereafter on all dates within the jurisdiction of the court. That for the purpose of jurisdiction, the court fee and the suit is valued at 100 and proper court fee is paid. Thereafter, his prayer was. The pro forma defendant prays for permanent injunction on the plaintiff from entering possessing the suit land shown in the plaint. He has not mentioned the specific schedule. He is only saying that suit land shown in the plaint means A, B, both he is claiming, Lordship. For correction of the Khatian in the name of pro forma defendant and Kasem Ali, son of late Sahib Ali. For declaration of right, title and interest of the pro forma defendant number 1, Kasem Ali and others in the suit land and cost of the suit. So only by the pro forma defendant number 1, there is not a single pleading by the defendant number 1, Lordship. She never says that I am the daughter of late Kasmati Beba and Muhammad Ali, Lordship. Now, Lordship, cross objection by the plaintiffs against the counterclaim, page Annexure 3, page 21. Cross objection means written statement against counterclaim by the plaintiffs, Lordship. They have denied the pleadings of the counterclaims. So, Lordship, now the plaintiff, defendant number 1, pro forma defendant become plaintiff in his counterclaim, Lordship. We have filed our written statement. Now the pleadings which he stated in his written statement and counterclaim, it is required to be proved by the pro forma defendant, as this is his counterclaim, Lordship. Normally, counterclaim and suit, Lordship, it is we take into consideration as 2 suits, Lordship. Against this, we have filed our Lordship reply against his counterclaim. Then our amended plaint is there, Lordship, in page 24, Annexure 4. We have amended our plaint and we have incorporated the other legal heirs of Shahar Ali, as they are also entitled for the 3/4 land of Muhammad Ali, Lordship, late Muhammad Ali. Now your Lordship will find page 24, Annexure 4. Amended plaint, Lordship. Now Qasem Ali become defendant number 3. Along with defendant number 1, Meherjan Bibi, that is adopted daughter, and Faizar Ali, her husband, and Muhammad Qasem Ali, brother of the Kasmati Bewa's husband's, Lordship, Muhammad Ali's brother. And other pro forma defendants are other legal heirs of Shahar Ali, Lordship, Saheb Ali. So they are not contesting, they have not filed any written statement. And as per this written statement, Lordship, Meherjan Bibi also not filed any written statement, and Faizar Ali also not filed any written statement. Thereafter, the pro forma defendant number 1 again filed his additional written statement, that is Annexure 4A, page 28, Lordship. So till now, there is no such pleading from the Meherjan Bibi, Lordship. So they cannot argue the case of Meherjan Bibi at the second appellate stage. But as this is a partition suit, Lordship, all are entitled, though they participated or not. But Meherjan Bibi, being not a legal heir of Kasmati Beba or Muhammad Ali, she is not entitled for any property. Only in our plaint in para 4, we have stated that out of love, already Muhammad Ali allotted some land to her. Para 4, page 8, the plaintiff stated that the defendant number 1 being maintained and brought up by Kasmati Beba and Muhammad Ali, out of love, got her name mutated in Dag number 42 with area 3 Katha with very intention to allot to the defendant number 1. As they were very well aware about the fact that in Mohammedan law, adoption is not recognized, Lordship. So already they have allotted some land to the Meherjan Bibi. As because they already knows that Meherjan Bibi cannot inherit the land of Muhammad Ali or Kasmati Beba. Lordship, as per Mohammedan law 347, adoption not recognized. The Mohammedan law does not recognize adoption as a mode of filiation. So, Lordship, inheritance she cannot claim through Kasmati Beba or Lordship Muhammad Ali. Only the dispute is between Qasem Ali, so he is filing the appeal, Lordship. In fact, Meherjan Bibi did not contest her appeal before this honorable court is not maintainable. Now, Lordship, trial court judgment. The plaintiff's adduce already, my learned friend has pointed out that plaintiff has to prove his own case, Lordship. He argued that plaintiff has to prove his own case. For that, your Lordship will find in appendix page 36. Plaintiff already adduced PW 1 to PW 8, 8 witnesses. And plaintiff exhibits are exhibit 1 to 10. All the order sheet, all the certified copy of Jamabandi, all documents were, Lordship, proved by official witnesses. I will come to that, Lordship. Only I am pointing that the plaintiff has proved his case by PW 1 to PW 8 and exhibit 1 to exhibit 10, adducing proper evidence, Lordship. Defendant, though filed his counterclaim, Lordship, only exhibited Exhibit A, working Khatian, Exhibit B, land revenue receipt, and DW1 Kasem Ali, DW2 Kishore Kumar Tamuli, and Yakub Ali, 3 witnesses. So I find there is no infirmity in the judgment of the trial court, Lordship. I am reading again page 33, issue number 5 and 2. 12, Lordship. Right title, interest of plaintiffs over suit A and B schedule land, and whether the plaintiff has 1/4 share over B schedule land. Both these issues are the real points for controversy between the parties. Before entering into the oral and documentary evidence of plaintiff side, let's have a look over the prime contentions of plaintiff side and defendant side. After careful and meticulous perusal of plain and written statement, it appears before the court that plaintiff instituted the suit for declaration of title and recovery of possession, contention that the Kaismati Bewa owned and possessed A and C schedule and inherited 1/4 share from B schedule land, and remaining land get by pro forma defendant number 1 to 3. So it is not a case that we are only claiming. It is a completely partition suit, Lordship. We are claiming our sister's share. She inherited through her father and from her husband, Lordship. 1 to 3, after death of Muhammad Ali, that the defendant number 1 is the adopted daughter and defendant number 2 is the daughter-in-law of Kaismati Bewa, live with Kaismati Bibi and looked after the property of A, B scheduled land, and out of love and affection said Kaismati gave 1 katha 6 lesser to defendant number 2 and 3 katha to defendant number 1. And plaintiff inherited suit land after death of Kaismati Bewa. On contra, defendants in their written statement pleaded that Kaismati Bewa not owned 4 bigha 2 katha 2 lesser and Muhammad Ali not left any land, and he gifted 5 bigha of land to defendant number 1 by deed number so-and-so. This is one of the pleading by the defendant, but Lordship, it was not proved that sale deed was also not exhibited. Gift deed was also not exhibited. The defendants further pleaded that the late Saheb Ali died leaving 28 bigha 3 katha 1 lesser, and he was survived by 4 sons, that is Muhammad Ali, Kasem Ali, Majibur Rahman, and Muslim Ali, and 2 daughters, namely Mohila Bibi and late Shaheda Bibi. That Muhammad Ali and heirs 3 brothers, and their 3 brothers got 5 bigha 2, 3 katha 12 and 1/5 lesser, but said Muhammad Ali sold 2 bigha 3 katha 15 lesser to Sodan Essa and another on 7/1/5 and 5 bigha to defendant number 1 on 11/3/76 by deed number so-and-so, dated so-and-so, which is in excess of his share. No exhibit, Lordship. No exhibit by these sale deeds were never exhibited by the.
Which paragraph you are reading? Paragraph number 10.
Paragraph 10.
Okay.
Last 2-3 lines, Lordship. Defendant's pleading is that, Lordship, that Muhammad Ali sold 2 bigha 3 katha 15 lesser to Sodan Essa. They did not deduce any evidence in regard to that, Lordship. And another on 7/1/5 and 5 bigha to defendant number so-and-so by deed number so-and-so, which is in excess of his share. My learned friend has argued that trial court and first appellate court onus was shifted to the defendant, and on the weakness of the defendant, plaintiff suit was decreed. It is not a case like that, Lordship, as because the defendants filed counterclaim, so burden is upon them to prove their case also. They never exhibited any document, Lordship. They are saying that Muhammad Ali sold in excess of his share, but no exhibit by the defendants, Lordship. From the pleadings of both sides, basically it appears that plaintiffs paying their right title interest over the suit land, claiming ownership of one Kaismati Bewa over suit land, claiming that Kaismati is wife of Muhammad Ali, get left suit land and who died issueless. It further reveals that the plaintiffs claim that defendant number 1 is adopted daughter of suit land, and due to love and affection, name of defendant number 1 recorded over 3 katha of land, and defendant number 1 looked after the suit A and B scheduled land, and subsequently defendant number 1 denied to vacate the suit land. On contra, defendants claimed that husband of Kaismati named Muhammad Ali gifted 5 bigha of land to defendant number 1 by deed number 2005/76 and 2 bigha of land to Soda Nessa in the year 1951. Plaintiff side in this case to prove their above contentions examined as many as 8 witnesses and exhibited 10 numbers of documents. On contra, defendant side examined as many as 3 witnesses and exhibited 2 documents. I have carefully gone through the oral and documentary evidences of both sides, where it appears that PW1 in his initial testimony supported the entire averments of plaintiff and exhibited 10 numbers of documents. From the cross-examination of PW1, it appears before the court that PW1 deposed that Saheb Ali was the father of late Muhammad Ali and said Saheb Ali died leaving 4 sons and 2 daughters. He cannot say whether Saheb Ali had left 28 bigha 3 katha 1 lesa of land. He cannot say whether Muhammad Ali acquired any property by purchase, settlement or exchange. PW2-1 Habibur Rahman submitted his examination in chief through affidavits supporting the entire averments of plaintiff. PW2 in his cross-examination testified that he don't know whether from Muhammad Ali got the suit land and he can where from Muhammad Ali got the suit land and he cannot say the boundary dag number of the suit land. From the oral and documentary evidence of plaintiff's side, it appears before the court Muhammad Ali is the husband of Kaismati Bewa and said Muhammad Ali and Kaismati Bibi died issueless. It further proved before the court that defendant number 1 is the adopted daughter of late Muhammad Ali and Kaismati Bibi, and plaintiff are the brothers of late Kaismati Bibi. Lordship, here I am pausing for a moment. From the exhibits, Lordship, 7 and 8. My learned friend has said that the trial court, without any evidence, said that defendant number 1 is the adopted daughter, Lordship. For that, I am reading exhibit 7 and 8, Lordship.
Page number?
No, Lordship, I am reading from the exhibits. These are in LCR, Lordship. With PW1, your Lordship has already gone through PW1.
Seven and 8.
Yes, Lordship.
Hmm.
7 is order dated 5/7/2001 in vernacular, Lordship. Here, Lordship, that defendant number 1 is the applicant, Meherjan Bibi. Bonam Keshavuddin, here it is written as Keshavuddin, maybe Kasemuddin, Lordship. Dorkhastokari Anupasthit. She was absent, Lordship. Protipokho Hajir ase, Dorkhastokari Musammad Meherjan Bibi, Shami Foizar Aliye, Borbila Prothom Khondo Gaor 41 নম্বর Miadi Potta 43 নম্বর Dagor, অংশ 1 বিঘা মৃত পট্টাদার কাইসমতি বিবিৰ ৱাৰিছ হিচাপে নামজাৰি পাবলৈ আবেদন কৰিছে। জাৰিকাৰকৰ প্ৰতিবেদন পঢ়ি পোৱা গ'ল। প্ৰতিপক্ষ হাজিৰ আৰু লিখিত আপত্তি দাখিল দিছে। So the respondent Kashem Ali filed his written objection, Lordship. দরখাস্তকারীয়ে গোচৰত দাখিল দিয়া registered দলিল নম্বৰ 29/1991 পঢ়ি চোৱা হ'ল। দলিল অনুসৰি কাইসমতী বেৱাৰ নামত বৰ্তমান পট্টা চলি আছে। কোনো 1 নম্বৰ উপায়ুক্ত কাৰ্যালয়ৰ পৰা মেহেৰজান বিবি কাইসমতী বিবিৰ ছোৱালী বুলি প্ৰমাণপত্ৰ দাখিল দিছে যদিও মেহেৰজানৰ স্বামীয়ে এই আদালতত হাজিৰ হৈ তেওঁৰ পত্নী মেহেৰজানৰ কাইসমতীৰ তুলনীয়া ছোৱালী Lordship it ought to be ছোৱালী বুলি স্বীকাৰ কৰে। So her husband admitted that she is the adopted daughter of Kaismati, Lordship. এই ক্ষেত্ৰত প্ৰতিপক্ষই উপায়ুক্তৰ হুকুমৰ আধাৰত মেহেৰান বিবি কাইসমতীৰ নিজা ছোৱালী নহয় বুলি আপত্তি দাখিল দিয়া বুলি এই গোচৰত জনাইছে। প্ৰতিপক্ষৰ অচিয়ত আলী গৈৰসহ গণৰ লাৰ্নেড এডভোকেট হাজিৰ হৈ মহমেদান ল ছেকশ্যন 347 মতে মুছলিম আইন মতে এডপশ্যন প্ৰযোজ্য নহয় বুলি আপত্তি দৰ্শায়। গতিকে সকলো দিশ পৰ্যালোচনা কৰি বৰবিলা প্ৰথম খণ্ড গাঁৱৰ 41 নম্বৰ ম্যাদী পট্টাৰ 43 নম্বৰ দাগৰ অংশ 1 বিঘা মাটিত কাইসমতী বেৱাৰ ৱাৰিছ হিচাপে তুলনীয়া ছোৱালী দৰখাস্তকাৰিনী মেহেৰজান বিবি স্বামী ফয়জৰ আলীৰ নামজাৰি আবেদন অগ্ৰাহ্য কৰা হ'ল। So her mutation application was rejected. No appeal was filed by the Meherjan Bibi, Lordship. She did never contested anywhere, Lordship. After filing this mutation application, no mutation appeal was filed. Lordship, moreover, she has not contested the trial court also, Lordship, by filing written statement. The exhibit 8 is also same, only plot numbers are different, Lordship. Here also, she was considered as a adopted girl, Lordship. Adopted daughter কাইসমতী বিবি তুলনীয়া ছোৱালী হয়। Second, প্ৰতিপক্ষৰ লিখিত আপত্তি মতে কাইসমতী বিবিৰ কোনো ঔৰসগত সন্তান সন্ততি নাছিল। Last paragraph, Lordship. Exhibit 8. দৰখাস্তকাৰিনী কাইসমতী বিবি তুলনীয়া ছোৱালী হয়। On that basis, that application was also rejected. No mutation appeal by the defendant number 1. So, Lordship, when her husband admitted in these proceedings, and these proceedings were proved by PW5, Lordship. PW5 is Abdul Khalek Pradhani, Lot Mandal, Lot number 8, Adabari, Utto Gusoror Samon, ASO Saraloi Dari Hoy, Aru ASO Sare Muk endorse Kori Samonot Ullekito Noti Hofa Adalatoloi Haki Dibo Pothaise. Moi DMPS 247/2000, Aru DMPS 249/2000, Aru DMPS 248/2000 case Noti Loi Anisu Aji. Exhibit Hapkhon DMPS number 247/2000 case of Paskora order dated 5/7/2001 or certified copy. DMPS case number 249/2000 of Paskora order dated 5/8/2001 or certified copy whole Exhibit A. Further examination reserved, Lordship. So PW5 proved my exhibit 6, 7, 8, 10, Lordship. 10 is another order, Lordship. In these orders, it is mentioned that she is the adopted daughter. So one point of argument my learned friend raised that
No,
she.
the question is whether this officer is supposed to decide whether she is a adopted daughter or not.
No, Lordship, it was already held in this proceeding that she is the adopted daughter. They never raised any objection in respect to these orders, Lordship. They never filed any appeal. And it is
No,
clearly
that was
mentioned.
not the issue before that
No,
concerned officer.
their contention is that she is not the adopted daughter, so she is entitled for entire property of Kaismati Bewa. On that ground, if she is an adopted daughter, then we are entitled, Lordship. Because as per Mohammedan law, she is not
So
entitled.
these orders were passed by the circle officer.
Assistant settlement officer, lordship.
Assistant settlement officer.
But lordship, I
The
am
question is
relying,
whether he is entitled to give us opinion.
no lordship, I am trying to project that she is a adopted daughter. How I should prove that, lordship? By adducing the evidence of an independent witness, PW2.
No,
He is also there.
can it be by the entry in the revenue record?
No, lordship, I am not saying that entry in the revenue record does prove that she is a adopted daughter.
Hmm.
I am trying to project that she is a adopted daughter from the admission of her own husband, lordship, in a mutation proceeding. It is clearly mentioned that in Exhibit 7, lordship. মেহেরজান বিবি কাইসমতি বিবিৰ ছোৱালী বুলি প্ৰমাণপত্ৰ দাখিল দিছে যদিও মেহেৰজানৰ স্বামীয়ে এই আদালতত হাজিৰ হৈ তেওঁৰ পত্নী মেহেৰজান কাইসমতিৰ তুলনীয়া ছোৱালী বুলি স্বীকাৰ কৰে. So it is admitted by her husband. To prove this document, I have to call one official witness, lordship, to prove this order.
No, this order, in order to prove this order, you call that official witness, that's all right, but whether
This order
that entry
reflects-
is final or it can be relied upon?
Yes, lordship, no appeal was preferred. It is mentioned in the.
Maybe.
But lordship, it is mentioned that her husband admitted.
Hmm.
So it is clearly proved that she is admitted, she is an adopted daughter.
Hmm.
Whether they tried to prove that Meherjan is the natural child of Kaismati and Muhammad Ali by adducing any birth certificate,
Hmm.
any certificate from, when we are saying we tried to present, we have already, lordship, proved that fact. Now burden shifts to them, lordship,
Hmm.
but they have not proved anything, lordship. Merely denying that she is not the adopted daughter, that too by the brother of Kasmati's husband, not by Meherjan. She is not before the court, lordship. She did never adduce any evidence. She did not file any written statement.
Yes, Mr. Iqbal?
My lord, with regard to the point of adoption, my lord, they have nowhere stated in the plaint as to who is my original biological parents are when I was adopted, my lord. So in absence of those pleadings, my lord, if my lord, my adopted parents have expired, so their evidence cannot be taken. But my lord, they could have very well taken the evidence of my biological parents if at all I was adopted, my lord. And in presence of which witnesses I was adopted, my lord. By following what customs, my lord.
No, my question is, can on the basis of Exhibit 7, 8
Exhibit
and 9,
My lord. Exhibit
it
7.
can be said that she is
It is just
adopted
like
daughter.
my lord, that in the circle officer sometimes decides the title of a case, my lord. Title of a sale deed, say sale deed is genuine or not, my lord.
Hmm.
The same way, my lord, he has decided, my lord, whether adoption has taken place or not. His jurisdiction was confined only to whether, my lord, mutation can be granted or not, whether I had possession or title. Only limited to those aspects. Whether I was adopted or not, my lord, that was beyond his jurisdiction, my lord. So that's why my submission is that, my lord, Exhibit 7 and 10 cannot be taken into consideration to decide whether adoption has taken place or not. Otherwise, my lord, it would create chaos, my lord. If my lord, if ASOs have to decide, my lord, adoption, then why civil courts are there, my lord?
No, lordship, he is not deciding adoption. He is saying that they have produced birth certificate from deceased office. I am not relying on that just because her own husband admitted that she is the adopted daughter.
And the birth certificate was not considered, and admission of a person, that is my husband, who was not present when adoption had taken place, that was considered, my lord.
Maybe
In
it
fact,
is
my
wrong, but
husband
they
was
have not
present or
appealed,
not, that is also, my lord, disputable.
No dispute, lordship, by them, lordship, disputing those findings, lordship.
92 of the evidence, my lord, is quite clear that, my lord, when document is there, oral testimony cannot be relied upon, my lord.
Yes.
Yes.
No, lordship, here it is clearly mentioned, these orders, Exhibit 7 was never challenged, lordship. It is their duty, they immediately have to file a title suit for declaration that she is the daughter of Kaismati and Muhammad Ali. When there is a finding against them, the Meherjan Bibi never filed any title suit for declaration. She is the child of lordship, that Muhammad Ali and Kaismati Baba. it attained finality though. Whatever may be the order passed in the revenue records, lordship, it attained finality. They never challenge. And even after we exhibiting the said order sheet before the learned trial court in a title suit, lordship, she remained silent, lordship. What does it mean, lordship? Even her husband also remained silent. They did never file any written statement, lordship. And it is a partition suit, your lordship. PW2, we have adduced evidence of PW2. He also admitted that he is an adopted child. PW2 is an independent witness, lordship. Cross part of PW2, your lordship will find. PW2 is I, Habibur Rahman, son of late Fazarullah Sheikh, aged about 40 years, by profession cultivator, resident of village Borobila Part 1, from the same village, lordship. Under PSN district Dhubri, do hereby affirm and depose as follows, that I am the co-villager of both the plaintiffs and defendants. He is an independent witness, lordship. On cross part, he is admitting that Mohirjan Bibi, Muhammad Ali, Tulonia Swali, Aru Bibadi, Mohirjanor Sami hoy. Bibadi means defendant number 2. Mohirjanok kuntu jomi dise najanu kintu mati dia buli jano. Badi Osiot Ali Kaismotir bhai. So we adduce independent witness to prove that she is the adopted daughter of Kaismoti. So adoption part is of our lordship, and they file counterclaim. Trial court decreed the suit. Counterclaim was dismissed, but no 2 appeals were not filed. Only 1 appeal, lordship. Against that counterclaim, there is no appeal till now, lordship. So adoption part, I think, lordship, I am satisfied, your lordship, that it is proved by the plaintiffs. They have, lordship, burden was on the plaintiff to prove that she is an adopted child, and it is proved by the plaintiff by adducing Exhibit 7 and by adducing PW2, PW5. These are sufficient to prove that she is an adopted child. There was no denial by the defendant number 1 and 2, lordship.
Maybe, but how far those
In fact,
exhibits can be relied upon? That is the question.
no, lordship, we have already proved, lordship.
Mhm.
We have, moreover, lordship, there is no need to prove exhibit the pleading as adduced by the plaintiffs in their plaint that she is the adopted daughter. It is not necessary, as because defendant number 1 and 2 never denied those pleadings, lordship.
Hmm.
So it is not necessary on the part of the plaintiff to prove those facts, but moreover, the plaintiffs prove their suit, lordship. As it is the plaintiff, his own case, he has to prove his lordship suit. And it is a partition suit, lordship. All are equally entitled for their share. Plaintiff number 3, plaintiff 1 to 4, and defendant number 3 to 5, lordship. 5, 6, 7. There are other legal heirs of Muslim Ali also. So, lordship, it is our case that that part is already sufficiently proved by the plaintiffs. Now, lordship, the trial court, considering those facts, page 34, lordship, I was reading in page 34. It also reveals that, internal page 5, lordship. It also reveals that after the death of late Muhammad Ali, Said Kasmati inherited the suit land and name of Kasmati Bibi recorded over the suit land. The documentary evidence of plaintiffs.
Which paragraph you were reading?
Paragraph 10, lordship, but page number, internal page 5.
Yes.
First line.
There are several paragraphs.
No, first line, lordship.
Okay.
It also reveals that.
Mhm.
It also reveals that after the death of late Muhammad Ali, Said Kaismati inherited the suit land and name of Kaismati Bibi recorded over the suit land. The documentary evidence of plaintiff's side supported the averments of plaint. As per Exhibit 3, name of Muhammad Ali and Kaismati recorded over Khatian number 74, and Exhibit 4 shows that name of Kaismati recorded over land of Patta number 108 under Dag number 82138. 43, which described in suit. A schedule of plaint Exhibit 5 shows that name of Kaismati recorded over Dag number 1745, and Exhibit 6 shows that name of Kaismati recorded over B schedule of plaint. As per Exhibit 7 and 8, it appears before the court that white DMPS number 247/2000 and 249/2000 prayer of defendant number 1 for mutation of her names over suit land cancelled, and against that order no appeal preferred by defendant. So the learned trial court rightly, after perusing 7 and 8, has lordship came to this decision, lordship. Exhibit 9 is one certified copy of sale deed stands in the name of late Kaismati Bibi, and PW 6 one official witness proved said sale deed before the court. Exhibit 9 shows that land measuring an area of 1 bigha 2 katha 3/4 lessa under Dag number 18, 39 and 40 over Khotian number 74 purchased by Kaismati Bibi from Muslim Ali, son of late Saheb Ali. Finally, Exhibit 10 document shows that name of plaintiffs recorded over land described in suit A schedule of plaint, which covered by Dag number 8, 21, 38, 43 and 89. And that order passed by the Exhibit 10 is still in force and no appeal preferred by defendant number 1 against that order. The learned trial court lordship clearly held that Exhibit 7, 8, 10, where the orders were mutation application was filed by defendant number 1, Meherjan Bibi. Those were lordship rejected by the revenue authority. Thereafter, she did not prefer any appeal. The learned trial court came to a finding that these orders attain finality, which says she has not filed any appeal, lordship. To sum up the oral and documentary evidences of plaintiff's side, it appears that suit B schedule land of plaint originally owned and possessed by the Muhammad Ali, who died on 4/5/2000, and after his death, Kaismati, being his wife, inherited 1/4 share. It is not the case of the plaintiff that they are claiming the entire property of Kaismati. They are only claiming 1/4 share, her entitlement, lordship. As per Mohammedan law, when there is no issue, only she is entitled for 1/4 share. And plaintiff, being as her legal heirs, inherited the same and remaining portions of land inherited by brothers and sisters of Muhammad Ali. The defendant reside with the Kaismati Bewa in her own residence in Dag number 43 with area 1 katha 6 lessa, and defendant number 2 look after suit A and B schedule of property. A schedule of plaint is owned and possessed by Kaismati Bewa along with movable including land of C schedule, who died on 27/10/2000, survived by her 2 daughters and sisters, that is the plaintiffs. Plaintiffs, being only the legal heirs of Kaismati Bewa, inherited her property and their names has been recorded duly over A schedule land by Exhibit 10. It further reveals that suit B and C schedule land owned and possessed by Kaismati Bibi, and after her death, present plaintiffs, being her brothers and sisters, inherited the same. It also appears that defendant number 1 is the adopted daughter of late Kaismati, and her prayer for mutation of name over suit A and B schedule rejected by appropriate authority by Exhibit 7 and 8. It further reveals that defendants are possessing the suit land and defendant number 1 looking after the suit land, and when the plaintiffs ask the defendant to vacate the suit land, the defendants turn on defund the request of plaintiffs. In the other hand, defendant side examined as many as 3 witnesses and exhibited 2 documents. The case, I have carefully gone through the oral and documentary evidence of defendant's side, and where I find that DW1 submitted examination in chief true affidavit supporting the entire averments of written statement, DW1 in his cross-examination testified that suit land earlier belongs to their father and suit land is 28 bigha. And after the death of his father, suit land mentioned between his partition between his brothers and sisters. But there was no exhibit in regard to this partition, Lordship. There was no exhibit from the defendant side showing any partition deed, Lordship. He further deposed that he do not know in whose name now the suit land recorded. He further deposed that he don't know what has written in his examination in chief. His brother Muhammad Ali got 4.5 bigha of land. Kaismati is the wife of Muhammad Ali. He don't read exhibit A and B. DW1 being defendant number 3 of this case failed to support his own contention through his cross-examination. DW3 even failed to say in whose name the suit land presently recorded. That shows defendant number 3 possessed no knowledge about the suit land. The documentary evidence of defendant's side says that exhibit A is working Khatian number 74. That indicates the land earlier belonged to Saheb Ali, and on his death, the name of Muhammad Ali recorded in Khatian number 74. And exhibit B is rent receipt. The defendant's side only proved one fact that Muhammad Ali gifted 5 bigha of land under Khatian number 74 of Dag number 18 and 40 by deed number so-and-so as per version of DW3. But the defendant's side failed to adduce any documentary evidence to prove deed number so-and-so. So it was rightly held, Lordship. They have not exhibited that deed, Lordship. If we accept the testimony of DW3 that Muhammad Ali gifted 5 bigha of land under Khatian number 74 by gift deed number so-and-so to Meherjan Bibi, defendant number 1, even then, that will not help the defendant's side. In this case, defendant's side failed to prove the fact that Kaismati not owned 4 bigha, 2 katha, 2 lesa, and Muhammad Ali not left any land. Defendant's side failed to prove the fact that Kaismati not owned 4 bigha, 2 katha, not left. Rather, he sold and gifted by deed number so-and-so of land from Dag number 18 bigha, 2 bigha. Dag number 18, 2 bigha, 2 katha, 10 lesa of land from Dag number 40 and delivered possession to defendant number 1, and she is possessing the same. These facts were, Lordship, pleaded by defendant number 3. Defendant number 1 never said that 5 bigha land was gifted to me, Lordship. Which the appellant is successful if in the appeal would be absolutely contrary to the decree which has also attained finality between his late brother and the defendants. They are mutually irreconcilable, totally inconsistent, laying one side by side. The only impression would be that one is in the teeth of the other. In one, the suit is dismissed, where in the other, the suit would have been decreed. Here, Lordship, the question of share will come. Now the present appellant is contesting, and moreover, Lordship, one important part is that the defendant number 1 claim counterclaim.
Whether the facts of that case is similar with the present case?
No, Lordship, not fair. But Lordship, in absence of some parties, whether the suit can be decreed, Lordship, appeal can be decided. On this point, the Supreme Court held that when the appeal awaited in respect to one defendant, the other defendant's appeal cannot be allowed, Lordship. Here in this case, all the parties are equally entitled for their share, lordship. So when the defendant number 3 is entitled for his share, the other legal heirs of Muslim Ali are also entitled for their respective shares. But lordship, in the counterclaim portion, your lordship will find the defendant number 3 is claiming his right over the entire property of Muslim Ali, excluding the other legal heirs, lordship. Only
What are the
he-
other judgments you have relied upon?
Lordship, that is
GLT.
lordship, second one is 2017 2 GLT 414. That is also in respect to relief in the suit being a joint decree co-defendant, such suit state abated on death of defendant number 2. When one defendant dies, lordship, the entire suit will abate. That is, in case the defendant 1 dies and no substitution was filed, then the entire suit will abate as because it is a joint decree, lordship. Here also, lordship, the same. They all are entitled for their respective shares, and here the appellant prayed for striking out the name of some of the parties who are also entitled for their respective shares, lordship.
Which paragraph you have relied upon of this judgment?
Here also state of Punjab and Nathuram was discussed in paragraph 25, lordship. Paragraph 25, lordship. From and now 26, from the ratio of the said decision of the Honorable Apex Court, it is very much clear that as the decree prayed for by the plaintiff respondents was a joint one against all the defendants, and the same cannot be separated so far the deceased defendant number 2 is concerned. Under such circumstances, the decree so passed by the first appellate court against the surviving respondents was totally ineffective, inasmuch as the decree passed by the first appellate court could not be successfully executed. The presence of one of the legal heirs of the deceased defendant number 2 herein this second appeal cannot revive the suit, inasmuch as she was not substituted in order to protect the suit from being abated. There also, lordship, one person was not substituted. The suit abated in respect to that defendant, lordship. When there is joint decree, that cannot be separated.
Yes, you have already submitted that whether they are plaintiff or defendant,
They all are entitled.
all
for
are
that.
entitled to a share.
But lordship, technically, defect is there in this regular second appeal. as
So
because
whether
lordship,
that technical defect is sufficient to dismiss this second appeal or not, that has to be looked into.
lordship, that will also come, lordship, in consideration as because lordship, during the pendency of the regular condonation application, they prayed for striking out the name of the one set of defendants, lordship, who are also shareholders. And one point my learned friend has pointed out that without pleading, no evidence can be laid, lordship. And he cited one judgment, 2008 17 SCC 419, lordship. In answer to that, lordship, I am relying on the judgment of 1983 SCC 72. Paragraph 10, lordship. My third judgment, lordship. It was contended by the learned counsel for the defendant that since the plaintiffs had failed to establish that they had contributed the price paid for the suit house, the suit should be dismissed without going into the question whether Bharat Singh had purchased the suit house with his money in the names of the plaintiffs for the benefit of plaintiff number 2. The plaintiff does not disclose the name of the person or persons who paid the sale price of the suit house. The suit is based on the patta standing in the names of the plaintiff. In the written statement of the defendant, there was an allegation to the effect that Even though the patta was standing in the names of the plaintiff, they were only Benamidars and the real title was with Bharat Singh and the defendant. The particulars of the circumstances which compel Bharat Singh or the defendant to take the patta in the names of the plaintiffs were not disclosed, although it was stated that it had been done so owing to some political and other surrounding circumstances and for the safety of the property. From the evidence led by the parties, we are satisfied that they knew during the trial of the suit that the question whether the transfer effected under the patta was a Benami transaction or not arose for consideration in the case. Even in the appeal before the High Court, the main question on which arguments were addressed was whether the transaction was a Benami transaction or not. Merely because the plaintiffs attempted to prove in the trial court that the money paid for purchasing the house came out of their funds, they cannot in the circumstances of this case be prevented from claiming title to the property on the basis that even though Bharat Singh had paid the consideration, therefore plaintiff too alone was entitled to the suit house. Reference may be made here to the decision of this court in Bhagavati Prasad Sri Chandramol, where the court observed as follows: there can be no doubt that if a party asks for a relief on a clear and specific ground, and in the issues or at the trial, no other ground is covered either directly or by necessary implication, it would not be open to the said party to attempt to sustain the same claim on a ground which is entirely new. But in considering the application of this doctrine to the facts of the present case, it is necessary to bear in mind the other principle that considerations of form cannot override the legitimate considerations of substance. If a plea is not specifically made and yet it is covered by an issue, by implication, and the parties knew about that the said plea was involved in the trial, then mere fact that the plea was not expressly taken in the pleadings would not necessarily disentitle a party from relying upon it if it is satisfactorily proved by evidence. The general rule, no doubt, is that relief should be founded on the pleadings made by the parties. So it is discussed that merely saying that there was no pleading, no evidence can be led is already discussed by the Supreme Court. Now, fourth one, Lordship, that is 2014 5 GLT 269.
On what point?
On the substantial question, Lordship. Para 7, Lordship. Not paragraph. In second appeal, the court is duty bound to find out as to whether a substantial question of law does arise from the facts and circumstances brought on record. In this case, prayer for declaring that a particular sale deed was forged, fabricated, and never executed, parties went to court knowing the nature and character of the suit and laid respective evidence, both oral and documentary, in support of as well as against the issues framed. The trial court considered the evidence available on record and then came to finding that Exhibit Khaw was never executed by Momin Ali. Raned First Appellate Court, after reappraisal of the records, upheld the view. Having so found, I do not find any substantial question of law involved in the concurrent findings of the learned courts below. Here also, Lordship, in this case, both the courts decided the suit of the plaintiff in favor of the plaintiff, Lordship. Against concurrent finding, Lordship, my humble submission before your Lordship that there is no such substantial question of law arises to consider, Lordship. Therefore, I humbly submit before your Lordship to dismiss the appeal, Lordship, and upheld the decree passed by both the courts below.
Yes, Mr. Iqbal.
My lord, I'll just take 5 minutes, my lord. My learned senior colleague has been consistently saying that this is a partition suit. And it was also admitted by the PW1 during cross-examination that this is a partition suit. Now, if it is a partition suit, my lord, then there has to be certain procedures as per laid down under Order 20, Rule 18, my lord. My lord kindly takes up Order 20, Rule 18. And
Order
20, Rule 18. When a judgment is passed under a partition suit, my lord, a preliminary decree has to be set out. the decree has to be sent to the collector under section 54 of the CPC, my lord. And thereafter, my lord, a final decree has to be drawn. Here in the present case, my lord, no preliminary decree has been granted and it has not been sent to the collector. Forget about, my lord, the final decree, my lord. What has been given is only recovery of possession, declaration of right title interest. So there is completely non-adherence of Order 20, Rule 18. My lord is got.
Yes.
Order 20, Rule 18, decree in suit for partition of property or separate possession of a share therein. When the court passes a decree for partition of property or for the separate possession of a share therein, then if and so far as the decree relates to an estate assessed to the payment of revenue to the government, the decree shall declare the rights of the several parties interested in the property, but shall direct such partition or separation to be made by the collector or any gazetted subordinate of the collector deputed by him in this behalf in accordance with such declaration and with the provisions of section 54. So, my lord, here, my lord, all the right title interest of all the party has to be declared, that is first. Then it has to be sent to the collector, my lord. And thereafter, as per section 54 of the Code of Civil Procedure, my lord.
Whether any question has been framed on this point?
No, no question.
Then
because, my lord,
can we go
today they have
beyond
taken a
the
step.
question framed?
My lord, any other substantial question of law that can be formulated?
No, that was not framed.
Not framed. Because, my lord, I was of the view that it was a suit, declaratory suit. Since they have been saying that, my lord, it is a partition suit. It is a partition suit simplicitas. So I'm saying, my lord, that there is non-adherence of Order 20, Rule 18. Furthermore, my lord, what my learned senior colleague has been submitting, that non-joinder of necessary parties. Now, we have taken the stand of non-joinder of necessary parties. Why, my lord? Sahib Ali had got 4 sons. That is the predecessor interest of the Muhammad Ali. He had got 4 sons, my lord. Muhammad Ali, Qasim Ali, Mujibur Rahman, that is the third in the list. He has not been made a party in the suit. Substantial question of law is there, my lord, in this regard. Third, then, my lord,
Then
Muslims.
let us frame one issue on this point.
My lord, it is already framed, my lord, non-gender of necessary. Issue number.
No, regarding this non-adherence to the
Order
provision
20.
of Order 20 Rule 8. Yes, madam?
Then lordship, your lordship has to fix another date for again hearing, lordship. After framing a substantial question of law, lordship.
Yes.
Again, it has to be heard.
Yes.
Well, but it is apparent that it has not been complied with. So whether we submit for or against it, my lord, there is no other
Fact,
way out
lordship,
but to.
it is a partition suit in the nature of a declaratory suit, lordship. Not a proper partition suit, but they prayed for their right title declaration as because there is a cloud from the defendants. They are denying our lordship entitlement, our right title. So we prayed right title interest with that lordship. As because they are not admitting our share, lordship. The Kaismati's husband's brothers are lordship denying our entitlement. So our prayer is also there, right title interest, lordship. So this is as held by
No,
both
the
courts,
question
lordship, it is a declaratory
arose
suit.
from your submission that you are asserting that this is a partition suit.
Lordship, I am saying that only because of lordship, all the parties have respective shares. Here only we are saying that respondent number defendants also have a share over 3/4 share. But lordship written statement was filed only by the one defendant. And he is claiming counterclaim lordship over the entire property. For that, I am saying
Now tell me, is it necessary to frame the additional substantial question of law?
No, not necessary, lordship. After so many years, it is not necessary as because already there are some substantial questions of law formulated.
Yes, anything, Mr. Iqbal?
Minor
courts after
non-gender of
considering
necessary parties, 2 of the legal heirs of Muhammad Ali, they have not been made a parties. That they have admitted in cross-examination also.
whether their counterclaim, they have made parties to that. And one
My
aspect I
counterclaim has
forgot,
already
lordship.
died, man.
One aspect I forgot, lordship, my learned friend has pointed out that plaint was not written affidavit. In the written statement also, there is no affidavit, lordship.
But this
So that objection
Okay,
cannot be raised
okay.
at the second appellate stage, Lordship.
Heard Mr. Iqbal, Iqbal, learned counsel for the appellant. And Ms. R. Sodori, learned counsel for the respondent. Argument concluded,
And
judgment
non-gender
reserved.
issue, Lordship, non-gender issue will not be sustainable as because, Lordship, in the
Okay, okay.
written statement,
Okay.
there is no mention of which of the parties are not implemented as necessary party.
Mhm.
And there also, Lordship, after the written statement,
Yes.
we have already amended our plaint, incorporated the other
Okay,
legal
okay.
acts, Lordship.
Item 21.
Obliged, Lordship.
deeply obliged.
The first appeal against the order of injunction, madam.
Where is the other side?
Other side, madam, cause is from the Vijay Mukherjee, madam.
Mm.
And service of respondent number 3 also complete, madam,
Mm.
insurance company. There is a urgency in the matter, madam, because there is a alleging, madam, truck, madam, which is restrained to transfer and transport, madam, in the name of my husband, madam.
And that's all right, but in absence of the other side, can we hear the matter?
Short date, madam. Short date maybe 6, madam.
Kobe? No,
November.
November. Heard Mr. K. R. Patgiri, learned counsel for the appellant, none appears for the respondent on call. List the matter
26 November.
sorted. In the event of subsequent non-appearance, appropriate orders will follow.
21st November.
Madam.
Item
Apply.
24. 24.
Yes, what was the issue on the other day?
We are on the point of interest, Lordship.
Hmm.
What should be the interest and there is a
Yes,
discussion
yes.
regarding interest. Lordship, I've made a small submission. I will give it on the main judgment which I am relying on.
Hmm.
Along with the, there's some reference to other judgments also.
Hmm.
Lordship, I can't go.
Put it. Put it.
So,
It's from the para number 24. Lordship, why I'm relying on this particular judgment. There are other judgments also, I will come to that. This judgment gives a ratio of what should be the.
error number 13.
24.
Yes.
Now we have to fix up the rate of interest. Section 171 of the MB Act empowers the tribunal to direct
Hmm.
that in addition to the amount of compensation, simple interest shall also be paid at such rate and from subject not earlier than the date of making the claim as may be specified in that behalf. Earlier, 12% was found to be reasonable rate of simple interest. With a change of economy and the policy of Reserve Bank of India, the interest rate has been lowered. The nationalized banks are now granting interest at the rate of 9% for 1 year. We therefore direct that compensation amount be fixed shall bear interest at the rate of 9%. Here, this case, why I'm cited this gives a reason. So it is need not be static. It will depend on the policy of the Reserve Bank and the bank interest. But if the right of
No, while arriving at such a decision,
yes, sir.
the court has not cited any reason. The only ground is that, only reason is that the nationalized bank
Yes.
has granted interest at the rate of 9% and therefore it should be 9%.
See, that is the
What is the logic?
not is that the amount that the claimant gets in any case the beneficiary gets that money Lordship, if it is kept in a bank account, he was
No,
it is
therefore, on the other day, I have told you that some principle has been laid down in that case, that Upahar Treasury case.
Yes, Lordship. The same Upahar Tragedies case was also from 12%. This was that 12% that has been referred to is Upahar Tragedies case. That has been, in Lordship may see my write-up, Lordship, there's another case where it has been referred to. United India versus Patriazine Mahajan, that's a very famous landmark case. In our view, the reason indicated in the case of Kaustubha Begum, this has been cited, is a valid reason. And it may be noted that the rate of interest is already on the decline. We therefore reduce the rate of interest to 9% instead of 12% as awarded by the High Court. So they are all, Lordship, this Kaustubha Begum's logic is followed. It should keep parity with the rate of interest prevailing in the bank. In any case, Lordship, when a person gets the money, he keeps in the bank. How much can the bank give? And Lordship, this interest on delay, Lordship, ideally a case should be decided 6 months, 1 year of the date of the accident. And insurance, somehow it gets delayed. The party who has been deprived of the amount of money.
Who is responsible for the delay? That has also to be looked into.
I'm just saying in general principle, what is the reason for granting interest? Granting is that the payment which was due to the claimant has been delayed for some reason or other. It has been delayed. That's why the insurance company should pay interest. He is entitled to interest. I'm just laying the general principle without going to the question who is at fault. So this is the basis. Suppose he would have kept it in the bank. How much would he have got? That should be a consideration. He would not have got 9%, 10%. If it is 7.5%.
Keeping the Mr. Goswami, keeping the amount in the bank is not the only option.
Yeah, there are hundreds of opportunities.
Yes, hundreds of.
Then mutual fund,
Yes,
can
yes,
go
yes.
for even share stocks and
Yes.
everything. But then the courts have tried to keep it very simple. Even this Honorable High Court, Guwahati High Court, also have raised this, taken this argument, and the judgment is saying that it will be 7.5%. I'm just trying for I just wanted to get the court interested in a line of argument. These are simple thoughts. I have penned down my thoughts.
Yes, yes.
Not to EA.
Okay.
But this indicates this is the only judgment that talks of in this, and I have been subsequently Patrice in more.
No, in some other cases also, Supreme Court has discussed why the rate of interest should be 9%.
But then they are not, it's not, no reasons are given. I have not found any reason that. But then recently.
No,
also,
that ratio has been followed, ratio laid down in the case of.
As recently as this year, it's a varying figure. No hard and fast rule can be laid down because I have a decision with me last year, even this year, the Supreme Court was granting 6%. And all that I'm trying to say, I leave it to the Honorable Decision Honorable Court.
Okay, Mr. Goswami, now you briefly tell me what were the points on the other day you have raised before this court?
Yes, sir. One
was interest.
One is the other was probably also. I'll let lots of me. One of the main point was deduction. The main challenge was the deduction should be 50% as a bachelor. So it should be 50%, not 1/3. That is a very subtle position of Lordship in Sarla Verma.
Deduction 50%.
Yes. That is my main point, Lordship. The other point, Lordship, this interest was this there. The other was income, I leave it to your Lordship.
National income has been fixed.
Yes. That's why they have taken a 7,000. I'll not press that particular point. But interest, Lordship, there's a matter of interest. Because probably neither will he be hard nor will I gain 1% this way, that way. I just wanted to thought the court should have a consistent line of. So I'm trying to discuss some principles only for that reason.
Okay.
There's another important point which I could not find any support. In this case, the owner of the vehicle died in the accident. The vehicle was neither registered nor was there deal. The London Tribunal came to a finding, yes, the owner of the vehicle had violated terms and conditions of policy, but then he did not want to pass on the liability to the father, who has been impleaded in place of the owner. Your Lordship had asked me to find out if there any legal support, decision or otherwise. I could not find in 2 days any such decision where such this particular point that the son has died, whether a liability of the son can be passed on to the owner. Whether the father can be made liable for the default of his son, not driving a vehicle which is neither registered nor was being driven with a license.
Okay,
The
you,
tribunal lordship rightly came to that finding, lordship.
Hmm,
That there is a violation of policy on the part of the deceased,
hmm.
who is the insured. And in his place, the father of the deceased was considered as a party. Whether the pay and recovery from the father can be granted, that was discussed. I mean, I'm not very, lordship, honestly, I'm not
Okay,
very sure.
if you
Whether
find
it can be passed
any support,
on. No, I could
you
not
may
find
inform
any support.
inform the court master.
Yes,
If
lordship.
you find any support
On this
within
particular point, very important
10,
point.
15 days, you can inform the court master.
Yes, lordship. Any point on this.
Okay.
And this interest part, I just passed in as a matter of interest. lordship.
Okay,
I have
okay.
done some
Okay.
thought about it, done
Okay,
some hard
okay,
work on this.
Okay.
I took the pain of doing it. So my simple sometimes the interest should be a little lower, at least 7.5% can go down. Because
What is
they-
the percentage given by, being given by the bank?
I'm a very senior citizen, I'll not get more than 75%.
No, that cannot be equated with a person who has already suffered damage, who was the only source of income of that family.
Please follow lordship 7.5. Any case.
We'll see.
25, lordship, just one. This judgment I brought to judgment just to show, lordship, that even Supreme Court has granted interest 6% even this year. This is the latest judgment, lordship. Just to show, lordship, I'm not pressing this that this should be 7.6%. I brought this, I found out this judgment, latest judgment, the interest at 6%. I'm giving you this one. So it's not uniform. 6% can also be granted in some. 25.
Heard Mr. Goswami, learned counsel for the appellant, and Mr.
Yeah, Mohsin also.
M. Hussain, learned counsel for the respondent. Argument concluded. Judgment reserved.
Respond number 1 and 2. lordship.
Respondent number 1 and 2. Yes.
My lord, I cannot complete in half an hour, my lord.
No, nowadays 45. 445. Acha. Oh. You cannot complete in half an hour.
My learned friend, my lord, next week I can do it, my lord, but on hearing date, not on Sunday.
Kove?
It's subject to his convenience.
Lordship, my learned brother can begin the procedure, but
Even
I keep it part heard.
No, even my lord, without hearing, my lord, he can be part heard, my lord, if you lordship. But if I started today, again, my lord, in another day I have started, I have to begin, I have to start from begin, my lord. That's why I'm submitting.
Up to my lordship, lordship can forget and fix it as a of the list. Otherwise,
But the problem is that we can provide you the date in the last part of November.
I have no objection, my lord, that is up to him, my lord.
November last two cases.
too late. I'm sorry.
Okay, we will keep it as part third.
Hello.
Lordship, it fairly at
It is a very serious point of.
21st November.
My lord.
I got more.
October 29.
No, 29, too many cases. Possibly.
November first week, my lord.
First week not possible.
Possible. Same thing will happen. Same thing will happen. Just try to understand.
Same thing will happen, yes.
21st, take it on 21st.
Then maybe.
Should we keep it as part third? Or not?
We not keep as part heard, but it may be listed as a top of the list.
Top
Because
of the
several
list.
times it has been lifted over, lordship. And this matter has been listed by filing a early hearing petition, lordship. With a liberty
Oh,
to
okay.
ensure upgradation. lordship.
Okay. Both the parties are represented by their engaged counsel. Due to paucity of time, the matter could not be heard. Recusal is the matter on
21st November.
21st as top of the list.